Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. Today is July 12th. It's 9:08 a.m. We're here for docket number 2020-125E. That is the application of Dominion Energy South Carolina Incorporated for adjustment of rates and charges, as opposed to continuing where we left off. It's my understanding that we have a settlement, so we will hear from the parties regarding that settlement. Before we get started, let's take a brief moment of silence, and I would like for us to send positive thoughts and prayers to former Commissioner O'Neal Hamilton. He lost his wife of 67 years last week. Commissioner Hamilton gave 16 years of service to the South Carolina, or the Public Service Commission of South Carolina, and he is dealing with the loss of his best friend, to say the least. If you would, please join me in a brief moment of silence. Thank you. Let's take roll. Present here in the hearing room, we have Commissioner Thomas, Commissioner Powers, Vice Chair Belzer, Commissioner Williams, Commissioner Caston, and Chairman Williams. Joining us virtually, we have Commissioner Irvin. Any preliminary matters from the parties before we proceed? Yes, sir.
Good morning, Mr. Chairman. Is this on?
I do not believe it is.
Good morning, Mr. Chairman. There we go. My name is Andrew Bateman with the South Carolina Office of Regulatory Staff. I wanted to first thank the Commission for allowing us to be back here in person. We really appreciate the opportunity. Mr. Chairman, Madam Vice Chairman, members of the Commission, if it pleases the Commission, ORS would respectfully request to give brief remarks on the settlement agreement and then introduce the settlement agreement into the record. As a preliminary matter, AARP, South Carolina, Frank Knapp Jr., Sierra Club, the Southern Alliance for Clean Energy, and South Carolina Coastal Conservation League, the South Carolina Department of Consumer Affairs, South Carolina Energy Users Committee, the U.S. Department of Defense, and all other federal executive agencies, Walmart, the South Carolina Office of Regulatory Staff, and Dominion Energy South Carolina Incorporated have signed on to a settlement agreement in this case. Counsel for CMC Steel has indicated that CMC does not oppose this settlement or the settlement agreement. Accordingly, the settlement agreement is comprehensive, both in scope of the issues before this commission in this proceeding, as well as its inclusion of all parties of record before the commission. The settlement agreement was filed with this commission on Friday, July 2nd, 2021. ORS believes that the settlement agreement offered is fair and reasonable and is a full resolution of all issues in this proceeding. If approved by the Commission, the average monthly residential bills using 1,000 kilowatt hours per month would see a monthly increase of approximately $1.81, which is only a 1.46% increase over their current bills. Just a few of the highlights from the settlement agreement include that DESC agrees not to file for a general rate case before July 1, 2023, such that new rates will not be effective prior to January 1, 2024, except where necessary due to unforeseen, extraordinary economic or financial conditions, which may include, but not be limited to, changes in tax rates. DESC commits to give up to $30 million from Dominion Energy shareholders as follows: up to $15 million to forgive pro rata share balances more than 60 days past due for all electric customer classes as of May 31st, 2021, and $15 million to fund a combination of energy efficiency upgrades and critical health and safety repairs that may be required in order for a home to receive energy efficiency upgrades to be administered by the South Carolina Office of Economic Opportunity. DESC commits to initiate a stakeholder process within 90 days after the Commission issues a final order approving the terms of the settlement agreement to examine an electricity affordability program for DESC's low-income customers and address the need for legislation to implement such a program. The parties to the settlement agree to stipulate into the record without objection or cross-examination the testimony and exhibits of each settling party. Mr. Chairman, I ask at this time that the settlement agreement, along with its attachments A through E, be marked for identification and entered into the record as the next hearing exhibit.
Okay. Before we do that, I want to take appearances from the parties and see if anyone else has any comments regarding the settlement agreement. And let me ask you this: would you consider the statement you just made an opening statement?
Mr. Chairman, I would not consider it an opening statement, but rather just brief preliminary remarks regarding the settlement agreement.
Okay.
Subsequent, and with your permission, I'd request that the ORS Executive Director and others interested have the opportunity to provide brief remarks on the settlement agreement as well.
Okay, so you're just telling us where we are. I
Absolutely,
got you.
yes, sir.
All right. Fine. Are you finished?
Yes, sir.
Okay. All right. Okay, we're going to take appearances from the parties, and we'll, once everyone has opportunity to give their opinion about the settlement agreement, if they have one, or opening statements, if you will, we'll move your document into the record.
Thank you, Mr. Chairman.
We're going to start with Sierra Club.
Good morning, Mr. Chairman. This is Robert Guile for Sierra Club. With me is Dorothy Jaffe with the club's environmental law program. And Ms. Jaffe will be presenting our settlement testimony for Mr. Harwood.
All right. Department of Defense and all other executive agencies.
Good morning, Mr. Chairman. Emily Medlin on behalf of the United States Department of Defense and all other federal executive agencies. I would, as far as just brief remarks, I would like first to thank the Commission for giving us a virtual option to attend the hearing. I very much appreciate the accommodation, but do look forward to a time when we can all gather in the Commission's hearing room. Regarding the settlement, I would like just to thank Dominion Energy South Carolina, ORS, and the other parties for engaging in meaningful and good faith settlement negotiations over these past 6 months. We had a lot of productive and useful conversations. The parties were very respectful and valued everyone's input, and that decorum, without a doubt, allowed the parties to enter into the settlement agreement. The federal government, and particularly the military, are large users of electricity from Dominion Energy South Carolina, so we were very interested in this rate case, and we are pleased that the parties could reach settlement and are here today to support it, and we would respectfully request that the Commission approve the settlement. Thank you.
Thank you, ma'am. And I just wanted to make sure Sierra Club understood that that was their opportunity to make any remarks on the settlement. Did you want to make any or not?
Mr. Chairman, this is Dorothy Jaffe. Can you hear me okay?
Yes, ma'am.
Okay, thank you. Yes, we do appreciate the opportunity to be here also. As Mr. Giles mentioned, we are here today to not only thank the Commission for giving the parties a 6-month pause in the hearing in order to negotiate a settlement, but to also ask the Commission to approve the settlement agreement without modification. The Sierra Club intervened in this case because we remained concerned about continued capital investments in Dominion's aging coal plants. And this settlement agreement, specifically paragraph 24, helps to alleviate our concerns by requiring Dominion to file public quarterly reports on the capital expenditures at the company's 3 coal plants. These reports will provide transparency to the Commission, the customers, and the public on the capital investments made at these coal plants, 2 of which Dominion stated it planned to retire in 2028 pursuant to its approved modified 2020 IRP. Sierra Club supports the settlement agreement, and we ask that you do so as well. Thank you very much.
Thank you, ma'am. AARP.
Yes, Your Honor. This is John B. Kaufman on behalf of AARP. Also in the room is Adam Prothero of Appleseed Legal, and he's also representing AARP. We are very grateful to the Commission for the fact that we are here today, and AARP intervened in this case because of our concern with the large size of the request and because of affordability concerns for many of our members who are on fixed or limited incomes. And as you know, we requested that the Commission delay the case about 6 months ago, and we are very thankful that the commission and that Dominion Energy South Carolina agreed to do that. And the past few months have been a very productive way for the parties to reach an agreement that is unanimous or nearly unanimous. We are a signatory to the July 2nd settlement agreement, and we believe that it contains many positive elements. We think it's a fair, just, and reasonable resolution of the issues amongst the signatories, that it's fair to Dominion. It gives a rate increase that is justified, as well as contains many features which we may get into later today that would not have been possible within the scope of this case without a settlement, and that will inure to the public's benefit. We think the size of the increase is reasonable. We are also particularly interested in the fixed charge for residential customers. We are glad that would only increase to $9.50, and that fixed charge is the BFC base facilities charge will be kept under $10. There are also features in this settlement of weatherization, arrearage forgiveness, and a process going forward where stakeholders can discuss potential new programs and approaches to affordability that would help some of our more vulnerable customers. So those are the highlights, and we do recommend and urge the Public Service Commission to adopt this settlement.
All right, thank you, sir. Walmart Incorporated.
Good morning, Commissioners. My name is Stephanie Eaton, and I am counsel for Walmart, Inc. in this docket. On behalf of Walmart, we thank the Commission and the parties for the privilege of participating in this docket, and we also appreciate the opportunity to participate virtually today. In South Carolina, Walmart operates 123 retail units and 4 distribution centers, 34 of which are within Dominion's territory. In fiscal year ending 2020, Walmart purchased $910.5 million worth of goods and services from South Carolina-based suppliers, supporting over 24,000 jobs. Walmart is significantly invested in South Carolina and its citizens, many of whom work at Walmart or with Walmart every day, and that is the reason Walmart originally intervened in this docket. When we began the hearing back in January, Walmart's primary focus was on 2 specific issues raised by Dominion's original filing. One was Dominion's requested return on equity of 10.25%. And the second issue was rate design of Dominion's proposed storm damage component rider. Since the Commission paused the hearing, Walmart has actively participated with all of the other interveners in about 6 months of extensive settlement discussions and with Dominion, and that has led to the comprehensive settlement agreement that is before the Commission today and to which Walmart is a signatory. Later today, you will hear from Walmart's Senior Manager of Energy Services, Lisa Perry. Ms. Perry filed her settlement testimony July 7th in support of the party settlement agreement, and she'll be here to explain how both of Walmart's primary issues have been resolved through these negotiations. The settlement agreement has near unanimous support from among the parties that have intervened in this docket. Walmart believes that the settlement agreement, when taken as a whole, is fair, just, and reasonable, and supports its approval by this Commission. Thank you.
Thank you, ma'am. CMC Steel, South Carolina. All right. They are excused and not present in this hearing. Department of Consumer Affairs.
Thank you. Good morning, Mr. Chairman, members of the commission. My name is Roger Hall. I'm the Deputy Consumer Advocate with the Department of Consumer Affairs. Also here today is Carrie Gruby-Leibarker, the agency's administrator and the state consumer advocate. The department would also like to thank the commission for granting the 6-month pause in this matter. As you all are aware, in recent cases, the department has advocated against rate increases during the pandemic and associated economic crisis. The pause not only gave the parties a chance to negotiate a settlement, but it also provided reprieve for consumers from potential rate increase during that time. Regarding the settlement agreement terms, as Ms. Gruby-Leibarker has previously stated, we believe the negotiations provided consumer-friendly resolutions such as the debt relief and the stay-out provisions that would not have been available through a formal rate proceeding. Therefore, we were pleased with the outcome and happy to join it. We would also ask the commission to approve it. Thank you.
Thank you, sir. Frank Knapp, Jr.
Thank you. Thank you, Mr. Chairman. Commissioners, I'm Frank Knapp, and I did intervene in this hearing, both as a residential customer and as a small business owner also. Wanted to thank the commission for allowing that 6-month pause, and it's wonderful to be back here in person.
Mr. Knapp, if you could pause 1 second, we want to make sure we get a camera on you while you're speaking. All right. Okay. Sorry about that. Please.
As long as I'm not breaking the camera, we're okay.
No, not at all.
Okay,
Please continue, sir.
Thank you. But anyways, thank you for the 6-month pause. It was very beneficial. It's great to be back here. I wanted to thank the leadership of the Office of Regulatory Staff during these negotiations, and also the Department of Consumer Affairs and all the other interveners who provided valuable information during these negotiations. I fully support this settlement agreement. I encourage the commission also to support this settlement agreement as it is presented to you. And with that, I would ask that I be excused for the rest of the hearing.
Well, not yet.
Okay.
Not yet. We want to ask you to hang out with us a little bit longer. But thank you. We'll try to get you out of here as soon as possible.
Thank you very much, Mr. Chairman.
South Carolina Energy Users Committee.
Mr. Chairman, it's a pleasure to see all of y'all in person today. Thank you for having us. The South Carolina Energy Users urges this commission to approve the settlement agreement that's before you. I think the testimony will reveal here this morning that the parties here, led by not only the Office of Regulatory Staff, but also Dominion Energy, worked tirelessly to reach a comprehensive settlement. The parties were all collegial. I think everybody engaged in good faith. It was just a pleasure. The resulting rates will be just and reasonable, and the energy users submits to you that the settlement agreement should be approved. Thank you.
Thank you, sir. South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Good morning, Mr. Chairman, members of the commission. This is Kate Mixon on behalf of the South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy. And with me here today is Attorney David Neal. To start, I'd like to also state our appreciation to the commission for allowing the 6-month pause and for the months of negotiation and hard work from all of the parties to reach settlement in this proceeding. SACE and CCL intervened in this rate case out of a concern for how Dominion's proposed rate increase and increase to the basic facilities charge would impact energy efficiency and affordability, particularly for Dominion's most vulnerable customers. And we are pleased that the settlement agreement includes terms to help mitigate these impacts in the short term and also address long-term affordability. The settlement includes a smaller increase to the basic facilities charge and a lower ROE than initially proposed. And as Mr. Bateman noted in his preliminary remarks, the company has also agreed to commit additional shareholder funds for arrearage forgiveness, energy efficiency, and critical health and safety repairs, in addition to undertaking a stakeholder process to evaluate affordability programs for low-income customers. Ultimately, SACE and CCL believe the terms of the settlement are fair and reasonable, and we urge the Commission to approve it. Thank you.
Thank you, ma'am. Dominion Energy, South Carolina.
Good morning, Mr. Chairman and members of the Commission. My name is Chad Burgess. I'm in-house corporate counsel for Dominion Energy, South Carolina. And with me today is Michael Anselmo. He's our outside counsel from the law firm of McGuire Woods. And it is a pleasure to appear before you today. And it's an even greater pleasure to be standing in front of you at this podium. It's been far too long. So I'm happy that we're all together again. And I just want to simply say on behalf of the company, thank you. Thank you for opening up your doors and allowing us to appear before you in person to finish up this most important proceeding. And I also wanted to thank you for pausing the proceeding back in January. A lot has changed in 6 months. And sometimes when you are provided with a little extra time, you can accomplish things that you thought might otherwise be unachievable. And time has a way of turning things around, and it certainly has done so in this case. So thank you, Mr. Chairman and members of the Commission, for providing the parties with that extra time. And I also want to express thanks to the other parties of record. Together, we worked diligently and in good faith over several months to negotiate a settlement that is complicated and it has integral terms and conditions that we're going to present to you here later this morning. And as you would expect, with all the varying interest among the parties, there were a tremendous amount of negotiations. And on behalf of the company, we are very pleased to be returning to you with the work product that we told you back in January that we'd be working so hard to produce and achieve. And Mr. Chairman, there's no reason for me to belabor all the nuances of the settlement agreement with you right now. I brought with me today Mr. Blevins, Mr. Rooks, and Mr. Kassam, and they're prepared to explain to you the fruits of our labor. That is the comprehensive settlement agreement. And we look forward to presenting them to you shortly. And after you have heard all of the settlement testimony from the other parties of record in this case, we respectfully request that this commission adopt and approve the settlement agreement as presented to you by the parties. Thank you, Mr. Chairman.
Office of Regulatory Staff.
Good morning, Mr. Chairman, Madam Vice Chairman, and Commissioners. With your permission, I would like to take just a few minutes to update you from where we left off on January 11th to the development of the comprehensive settlement agreement that's been submitted to you on July 2nd. As many have stated before me, first and foremost, this settlement agreement would not have happened but for the pause that you granted us in Order 2021-18. The time that you provided us, we did not squander it, but we did use all of that time. Second, on behalf of ORS, I thank each and every party for their participation and the constructive and creative discussion that we had that led to this settlement agreement. The 5 monthly reports that were submitted to the Commission demonstrate that the parties engaged in a dedicated, diligent, and determined process to reach a settlement. I use the term constructive compromise, and I use that term deliberately. The parties to this settlement agreement, in our discussions, we all recognize that we were in a unique situation without a guidebook. No one has all the answers when dealing with a state of emergency due to a pandemic. We knew we needed to provide collective support for customers who were and are facing unprecedented circumstances, financial as well as emotional. We also knew that we needed to continue to ensure that the company provided safe, reliable, and high-quality electric service. So this settlement agreement, if you will, is just that. It's a constructive compromise. As mentioned earlier, there are provisions that are not achievable outside of a settlement agreement. Specifically the stay out provision, which has been mentioned earlier, and the shareholder commitments. Specifically, there's the doubling of the annual commitment by the Dominion shareholders to $1.5 million to the Energy Share Program for years 2021 and 2022. And uniquely, $500,000 of that amount will go to small businesses. Now, and that's unusual. We made a point to look at all customer classes with this settlement agreement. And as mentioned earlier, up to $15 million for forgiveness of arrearages that are more than 60 days past due for, again, all electric customer classes. And as mentioned again earlier, the $15 million for energy efficiency weatherization. So the agreement actually has some very unique provisions as well. One of the more unique provisions is a creation of a stakeholder process to examine an electricity affordability program for low-income customers. But there are also numerous reports and studies, specifically the reporting as advocated by Sierra Club for the information related to capital expenditures for the company's 3 coal plants. But there's also a lead lag study and a cost-benefit analysis of any future grid investment plan for cost recovery. But finally, the agreement also, importantly, supports the continued provision of safe, reliable, high-quality electric service. The agreement does this by providing for continued vegetation management, recovery of storm damage costs, the allowance of transmission investments, the allowance of certain economic development costs, as well as efficient integration of renewable resources. We mindfully announced at the start of these negotiations that this agreement must be inclusive, such that everyone can support or at least not oppose this settlement agreement. Testifying in support of this comprehensive settlement agreement on behalf of ORS is Dawn Hipp. She is our Chief Operating Officer. We respectfully request that the Commission consider this comprehensive settlement agreement and consider approving it. We submit that the settlement testimony that you're about to hear from all the parties, including ORS, demonstrates that the provisions reflect a constructive compromise, that the provisions are beneficial to consumers, and support the continued provision of safe, reliable, high-quality electric service. Thank you.
All right, thank you, ma'am. We've heard from all the parties regarding the settlement agreement. Just want to address my colleagues here for a second. Obviously, the commission has nothing to do with the terms of this settlement agreement. Our role is exclusively to approve or deny. The rules of evidence prohibit us from asking questions about settlement negotiations. And I would ask the lawyers to make sure that if you feel a question is getting to the merits or too close to the details of settlement negotiations, please feel free to object. Oh no, I want to make sure we stay away from that variant. So before we allow Mr. Knapp to be excused for today, I wanted to make sure that my colleagues didn't have any questions for the lawyers, representatives for each party. Okay, so hearing from the lawyers, it's my understanding that all the lawyers and representatives believe that the settlement agreement is in the best interest of their clients or the individuals or groups that they represent, that the settlement is fair, just, and reasonable, and that there is unanimous consent, with the exception of CMC Steel South Carolina, who does not object, but there's unanimous consent by the parties for the commission to accept the settlement agreement, accept and approve the settlement agreement. Without going through the list of parties, if that is not correct, please say so. All right. Any questions from the commissioners for the lawyers or representatives? Commissioner Powers.
Mr. Chairman, are any of the witnesses going to be provided this morning?
Oh, yes, sir. Yes, sir. I just wanted to make sure before the witnesses give their testimony that you all didn't have any questions for the lawyers.
Thank you.
No. All right. Mr. Knapp, you may be excused. And Attorney Bateman, the settlement agreement will be marked and entered into the record as hearing exhibit 38. All right. Applicant, please call your first. I'm sorry. Do we need to sanitize, Executive Director Boyd? Yes, sir. All right. Let's. Do we need to take a break for that, or can we remain in place? Okay, so we're going to remain in place unless you need to, let's just take a 5-minute recess. Good morning, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in docket number 2020-125E. Let's take roll. Present in the hearing room are Commissioners Thomas, Powers, J. Williams, Caston, C. Williams, and Belzer. Joining us virtually is Commissioner Irvin. Sierra Club, please call your first witness.
Yes, thank you, Mr. Chairman. Sierra Club calls Will Harlan.
Mr. Harlan, please take the stand and wait to be sworn in by our court reporter.
If you'll raise your right hand, please. Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Mr. Harlan, can you please state and spell your name for the record?
William Harlan, William Harlan.
And who are you employed by and in what capacity?
I am the senior campaign representative for Sierra Club.
And did you cause to be prepared and pre-filed in this case 3 pages of direct testimony on July 7th?
Yes.
And did you have an opportunity to review that testimony?
Yes, I did.
Do you have any changes or revisions to your direct testimony?
There is one very small change I'd like to make if possible.
Can you please identify that?
Yes, on pages 2 of 6 and 3 of 6, there is a reference to attachment C, parts 1 and 2. That should be attachment E, parts 1 and 2. So change attachment C as in Caston to attachment E as in Irvin.
Thank you. And if I were to ask you the same questions contained in your pre-filed direct testimony today, would your answers be the same?
Yes.
Mr. Chairman, I would move that Mr. Harlan's pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Harlan's pre-filed direct testimony will be entered into the record as if given orally from the stand.
And Mr. Harlan, did you prepare a summary of your direct testimony?
Yes.
Can you please read that for the commission?
Certainly. First, I just want to thank the commission for holding multiple public hearings on the Dominion rate case that allowed ratepayers to express their concerns. Some of those hearings lasted late into the night, and Sierra Club appreciated the commission's willingness to hear from so many folks. Also want to thank the commission for pausing the hearing and allowing parties to engage in settlement discussions. Sierra Club has participated in those discussions over the past few months. On July 2nd, a settlement agreement was reached and signed by Sierra Club and filed with the commission. Paragraph 24 of the settlement agreement addresses our concerns in this case. It requires Dominion to file quarterly capital reports on Watery, Williams, and coal plants until the coal retirement studies are complete. These quarterly reports will ensure that parties to this proceeding and the commission are kept apprised of ongoing investments made at these aging uneconomic coal plants. So thanks to the leadership of this commission, these quarterly capital expenditures will line up well with the coal plant retirement docket that has been opened and will inform the commission about the cost of these coal plants to ratepayers moving forward. So on behalf of Sierra Club, I recommend that the commission approve the settlement agreement without modification.
Thank you. Mr. Harlan is now available for cross.
Questions? Well, you said cross. My understanding is that we're not crossing the witnesses. You just mean
Sorry,
commissioner questions?
have it.
No, it's okay.
Yes, please.
It's okay. All right. Commissioner questions for Mr. Harlan. All right, Mr. Harlan, there are no questions for you. You may step down.
Thank you.
Department of Defense and all other executive agencies. Witness Garrett.
Good morning again, Mr. Chairman. DOD FEA calls Mr. Mark Garrett to the stand.
Mr. Garrett, please take the stand and pause to be sworn in by our court reporter.
If you'll raise your right hand. Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Garrett, please state your name for the record.
Mark E. Garrett, Garrett.
By whom are you employed and in what capacity?
I am the president of Garrett Group Consulting, Inc., a firm specializing in public utility regulation.
In connection with this proceeding, did you prepare and cause to be pre-filed your settlement testimony consisting of 11 pages?
Yes.
Do you have any changes to your pre-filed settlement testimony?
No, I do not.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
Mr. Chairman, I would move Mr. Garrett's pre-filed settlement testimony into the record as if given orally from the stand.
Mr. Garrett's pre-filed settlement testimony will be entered into the record as if given orally from the stand.
Mr. Garrett, have you prepared a summary of your pre-filed settlement testimony?
Yes, I have.
Please proceed with your summary.
The stipulation results in an overall revenue requirement increase of approximately $35.6 million. This is down $142.6 million from the requested increase of $178.2 million. This is an 80% reduction in the requested level. In my direct testimony, I supported a revenue requirement increase of $26.9 million, which was an 85% reduction in the requested level. In my opinion, a $35.6 million increase, which is an 80% reduction in the requested level, is a reasonable result. With respect to cash working capital, I testified that the company is requesting $111 million in cash working capital based on a 45-day formula, or the 1/8 method. This method assumes that revenues are received on average 45 days after all expenses are paid. This is never the case. I pointed out that a lead-like study which compares the timing differences between the inflows of cash from revenues and the outflows of cash from each type of expense is the most accurate way to determine cash working capital needs, and is the approach used in the vast majority of states. I recommended that the Commission adopt the policy that a lead-lag study is essential to a positive cash working capital requirement. Without a lead-lag study, the cash working capital should be set at zero because a well-run utility should have a negative balance. I also pointed out that the lead-lag study would likely save ratepayers about $11.5 million per year. In the stipulation, the company has agreed to conduct a lead-lag study in the next rate case. In my opinion, this is a reasonable outcome for this issue. With respect to excess deferred income taxes, I testified that the company is amortizing its property-related unprotected EDIT over the useful life of the associated property, which could be up to 50 years. I pointed out that unprotected EDIT can be amortized over any period the Commission chooses. I recommended a 4-year amortization. The parties agreed in the stipulation to amortize the property-related unprotected EDIT in an amount each year that would reduce the stipulated revenue requirement increase of $61.6 million to a net increase of $35.6 million. This results in an amortization each year of about $26 million, which is approximately a 4-year amortization of the $99.5 million EDIT balance. This is a reasonable result in my opinion. With respect to incentive compensation, the company agrees to eliminate earnings-based incentive compensation from its recovery in this case. In my direct testimony, I set forth why earnings-based incentive payments should not be included in rates. I pointed out why earnings-based incentives benefit shareholders more than they do ratepayers. I also pointed out that this is the general treatment of incentive compensation across the country and the preferred treatment in South Carolina as well. The stipulation eliminates earnings-based incentives and results in savings to ratepayers of about $5 million annually. This is a reasonable result. With respect to storm damage cost, I testified that the company is requesting a total increase of $18.6 million annually for storm damage above the test year level. This increase consists of $8.8 million to amortize past storm costs and $9.8 million to accrue a reserve for future storm costs. In my testimony, I pointed out why these increases were unnecessary and why this is a bad time to pre-fund a storm reserve. The stipulation effectively removes about half of the $8.8 million amortization of past costs and all of the 9.8 million increase for future costs. This is a reasonable result in my opinion. With respect to major turbine maintenance costs, the company requested that turbine maintenance expense be increased by 10.6 million from 18.4 million to a $29 million annual balance based on estimated future costs. The requested increase also included maintenance costs for the recently acquired Columbia Energy Center. In my testimony, I pointed out how the current accrual for major turbine maintenance has actually decreased the company's regulatory asset for deferred maintenance costs over the past 8-year cycle. In other words, the current accrual has been more than enough. I also acknowledge that expenses have increased, should be increased for the Columbia Energy Center by about 4.6 million. I also recommended another $1 million increase. In total, I recommended an increase of 5.6 million. That was $5 million less than the company requested 10.6 million. The stipulation reduces the company's requested increase by about 4.1 million, which is a reasonable result in my opinion. Regarding Rate 23 availability, I testified that the availability of Rate 23 is limited to customers classified as manufacturing customers. I testified that tariffs are typically available to customers based on usage characteristics such as size or load factor. I said that the Rate 23 availability clause is unduly discriminatory. I recommended that the company revise the availability provisions of Rate 23 to include customers having a contract demand of 1 megawatt or more and an average annual load factor of 60% or higher. This would base the availability of Rate 23 on the load characteristics of the customer rather than on the type of business the customer is in. The stipulation makes Rate 23 available to customers with a contract demand of at least 1 megawatt and an annual average load factor of 60%. Regarding cost of capital, the stipulation provides that rates in this proceeding shall be established based on a 9.5% return on common equity and a capital structure that includes 51.62% equity. Dr. Zen Zhu provided testimony on behalf of DOD FEA, recommending an ROE of 9.1% and a capital structure with 52.56% equity. The company requested an ROE of 10.25% and 53.35% equity. In my opinion, the stipulated 9.5% ROE and 51.62% equity is a reasonable compromise in this case. In conclusion, I recommend that the Commission accept this stipulation.
Thank you. Mr. Chairman, Mr. Garrett is available for questions from the Commission.
Questions for Mr. Garrett? Hearing none, Mr. Garrett, you can step down. Thank you.
Thank you.
AARP and Office of Regulatory Staff, Ms. Emma Myers and Ms. Dawn Hipp.
Thank you, Mr. Chairman. While the panelists are taking their seats, I wanted to thank the Commission for allowing us to present these witnesses via a panel. Thank you.
You're welcome.
Your Honor, this is John Kaufman. Would you like each of us to ask questions of the witness in succession before questions from the Commission?
Yes, we'll start with Attorney Bateman since he's here with us.
Okay.
Okay.
I'm sorry, moving too fast. Ladies, would you please allow yourselves to be sworn in by our court reporter?
Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I do.
Thank you.
Ms. Hipp, please state your full name and occupation for the Commission.
Good morning. My name is Dawn Hipp, and I'm the Chief Operating Officer with the South Carolina Office of Regulatory Staff.
And are you the same Dawn Hipp who pre-filed 8 pages of settlement testimony in this case on July 7th, 2021?
Yes, I am.
Do you have any changes or corrections?
No, I do not.
Mr. Chairman, at this time, I'd ask that Ms. Hipp's settlement testimony be read into the record as if given orally from the stand.
Ms. Hipp's settlement testimony will be read into the record as if given orally from the stand.
Thank you. Ms. Hipp, did you prepare a summary of your testimony for the commission?
Yes, I did.
Would you please give your summary?
Certainly.
Thank you.
Good morning, Chairman Williams, Vice Chair Belser, and other commissioners. It is indeed a pleasure, as you've heard, kind of like Chick-fil-A, to be here in person and to have the exciting honor of presenting to you a comprehensive settlement agreement that would have only been possible had you graciously allowed us the 6 months to work diligently on the settlement agreement. We are grateful for those 6 months. ORS fully supports the settlement agreement, and we request that the Commission consider approval of it as it was filed on July 2nd. It's clear from the comprehensive settlement agreement that each of the settling parties made compromises from their original positions to achieve a balanced resolution of all issues, to provide customers who needed help the most with some targeted benefits, and to express their collective support for Dominion's recovery of reasonable and prudent investments to provide reliable and high-quality electric service to its customers. ORS believes a comprehensive settlement agreement is in the public interest for 3 reasons. 1, the overall reduction in the revenue requirement increase, coupled with the decrement rider, significantly mitigates the company's rate application for Dominion's customers as they recover from the lingering financial impacts of the pandemic. And for example, a residential customer on rate 8 using 1,000 kilowatt hours per month will experience an increase of approximately $1.81 compared to the increase of $9.68 as proposed in the company's application. The reduction in annual revenue requirement is enhanced by the decrement rider, and it further reduces the overall annual impact to customers to approximately $35.6 million per year, which, as you have heard, is an 80% reduction from the original amount requested by the company. The comprehensive settlement agreement also contains several provisions that provide benefits to customers, and these benefits would not have been achieved absent the compromises of the settling parties. For example, a benefit to customers is the company's agreement to stay out from a general rate case and to not file one before July 1st, 2023. This means that customer rates will not be impacted by a general rate case until January 1st, 2024 at the earliest. The company has committed shareholder funds to double its annual commitment to Energy Share and to assist customers with arrearage forgiveness and energy efficiency and critical health and safety repairs. Notably, this financial assistance is provided by the shareholders and is not only for residential customers, but will also include $500,000 of energy share assistance to small business and small general service customers. There are long-term benefits contained in the settlement agreement, specifically the commitments that Dominion has made to initiate 2 stakeholder processes. One process will review and monitor low-income weatherization efforts and discuss how the shareholder-funded arrearage forgiveness monies will be distributed. The other stakeholder process will examine an electricity affordability program for low-income customers and address the need for legislation to implement such a program. These stakeholder processes have the potential to make some significant strides on behalf of the utilities customers. Third and finally, the comprehensive settlement agreement includes provisions that support continued investment in reliable and high-quality electric service. As we know, resilient and reliable electric service is a necessity. It's not a luxury for all classes of customers, and therefore continued vegetation management and recovery from storm damage and recovery of storm damage costs are supported by certain provisions in the comprehensive settlement agreement. ORS respectfully requests the Commission consider approval of the comprehensive settlement agreement as presented, and if approved, the customers will begin to receive these benefits as early as September 1st, 2021. This concludes my summary.
Thank you, Ms. Hipp.
All right, sir. Mr. Kaufman, I believe.
Yes, thank you, Your Honor. Ms. Myers, would you please state your full name for the record?
Yes, Emma McGraw-Myers.
And in what capacity are you here and on whose behalf?
I am representing AARP. I'm volunteer state president.
Great. And what is do you know the estimated number of AARP members in the state of South Carolina?
Absolutely. We are over 600,000 strong.
Great. And are you familiar with the comprehensive energy settlement that has been discussed today, that was filed on July 2nd?
Yes, I am. Yes.
And are you the same Emma Myers that has caused to be filed testimony in support of this comprehensive settlement on July 8?
I am.
And if I ask you the same questions in that written testimony that was filed on July 8, would your answers be the same today, or would you have any corrections or modifications?
The answers would be the same.
Great. Well, at this point, Your Honor, I would ask that the settlement testimony of Emma Myers be read into the record as if given orally on the witness stand.
The settlement testimony of Ms. Myers will be read into the record as if given from the stand.
Thank you. Ms. Myers, are you prepared to give a short summary of the testimony that you had that was filed on your behalf?
I am.
Please proceed.
Thank you. Good morning, Chairman Williams and commissioners, those of you present, and of course those who are virtual. My name is Emma McGraw-Myers. I am State Volunteer President of AARP South Carolina. AARP strives to improve the quality of life for those 50 plus and their families. We advocate for issues that directly impact our members, such as financial security, government accountability, utility reform, senior hunger, and caregiving. I am pleased to report that more than 600,000 AARP members are here in the good state, or the proud state of South Carolina and Palmetto, the Palmetto State. AARP was alarmed when Dominion Energy South Carolina proposed a huge increase in the electric rates back in May 2020. This was the beginning of COVID-19, and it affected many members of AARP. They live in Dominion service territories, including myself, and can just barely get by on low and fixed incomes. They struggle to make ends meet and would be severely impacted by the proposed electric rates increase. AARP was concerned that the utilities' requests, if granted, would have a devastating blow on these customers 50 and above. These consumers devote a higher percentage of their total spending, more than average groups do, for residential utility costs. Many older consumers also have special needs and safety concerns that relate directly to having access to electric services. These are some of the considerations that led to AARP intervening in the rate increase case. As an intervener, AARP supports the settlement. AARP sent a letter to this commission in January asking for consideration of a 6-month pause in this case. This would allow parties to come together and submit a settlement. I'd like to say thank you for granting that pause, as it placed a 6-month freeze on utility rates and, of course, during an unprecedented pandemic. Our members in remarkable numbers testified before you in January about their concerns and what higher rates would mean to them. All parties listened and went to work to reach a settlement agreement on their behalf. During this 6-month pause, AARP lawyers and experts with Dominion and other parties to develop the proposed settlement got busy. AARP is a signatory of the document filed on July the 2nd, 2021. The proposed agreement is a just and reasonable way to resolve this rate increase. AARP believes that this settlement has many positive features from a consumer perspective. It will serve the public interest in ways that would not have been possible without such a settlement. The settlement includes several important features for residential consumers. For example, the overall rate increase for residential electric customers would only be $1.81 per month. That's approximately 1.46% increase for a household with typical usage of 1,000 kilowatts per month. This compares to the utility's original proposal increase of $9.68 per month. Another area is the settlement freezes these new base rates for nearly 2.5 years or until January of 2024. The settlement also allows for the fixed rate part of the residential electric bills to only increase to 50 cents. That is from $9 to $9.50 per month. AARP is extremely pleased that this fixed consumer charge will remain under $10 as it is an unavoidable fee and cannot be reduced through energy conservation. Dominion is also providing up to $30 million from stakeholders' funds to assist with vulnerable and economically challenged customers at no cost to ratepayers. This will help those who have been affected by the pandemic and addresses critical upgrades for home weatherization. Lastly, the settlement also provides a stakeholder process to explore solutions for the disparities of affordability that many individuals and families face when it comes to their utility bills. In closing, these items are some that both sides compromised on. However, the settlement agreement is a giant step forward for the state of South Carolina and will be a welcome relief, especially for those 50 and above and their families. Thank you.
Thank you, Ms. Myers. I believe that's all that we have with preliminary questions, and Ms. Myers would be available for any questions from the commission.
Thank you, sir. Thank you, Attorney Bateman. Commissioners, questions for this panel?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you. And as a non-attorney, I'll be looking at our attorneys because I certainly don't want to ask anything that I shouldn't, but I'm curious about some aspects. Ms. Myers, thank you for being here, as well as Ms. Hipp. Ms. Myers, I'm wondering how the 1.46%, I think, increase relates to the typical increase of your members. I think we had some testimony on it, but I didn't go back to look at that from the public hearing. That may or may not be a number you've got at your ready, but
I do not, but maybe Don does.
I might be able to help you
Awesome.
on that. We took a look at this increase of 1.46% and compared it to the consumer price index. Since the last company rate case, which those rates went into effect in 2013. And over time in the home energy sector, that rate, according to the Consumer Price Index, has gone up 10.6%, approximately 10.6%. So this 1.46% increase is much less than that.
thank you. Appreciate
Welcome.
that. On page 4 and 6 of Ms. Myers' testimony, you talk about the stakeholder process. This may be a question that others may want to answer, but I'm just curious in terms of the affordability problems, whether that is something that you all will report to the commission as that is ongoing. So I guess that I asked that of both of you.
Yes, absolutely. Affordability is an issue, and as you see, I described it as a disparity because our populations are challenged, first of all, because of limited income. And so as we start talking about families that are having to deal with, in particular this population, we talked about some of their special needs, They are on continuous oxygen. They are relying on, I have a couple of clients that are on wound vac machines. And so having to maintain the electricity is a critical issue. So the question is affordability. Is that something we're concerned about? It is a long-term issue that I don't think will be resolved. Don, can you speak to some of that as well?
Certainly. I think to your question about would the stakeholders report back to the commission, most certainly, we will be glad to do that. In other states where they look at electricity affordability programs, oftentimes that leads to the need for some sort of legislation. Ultimately, any affordability program that an electric utility wishes to implement would need to come before the commission for approval.
Thank you. And is there a timeline for that stakeholder process?
There's a kickoff timeframe within 90 days of this commission order, but it does not have a termination end date. And looking at what other states have done in the arrearage forgiveness area and looking at affordability type plans, it will take some time.
Thank you very much. I appreciate it.
Thank you for your question.
Mr. Chairman,
Commissioner Thomas, you have the floor, sir.
thank you. Appreciate you all being here today and helping us out and walking us through some of this. I'm very, very appreciative of the process that all of the parties went through to get to where we are today. I know it was a lot of work, and I do sincerely appreciate that. I would just like to ask, I guess, Ms. Hipp, in connection with the 100% recovery of the transmission investments. So you believe that that's in the best interest of the customers?
Yes, we do.
And so based on the amounts and the stipulation, have all of the assets been included in the settlement, or are there additional amounts that could end up coming before us?
Given the rate application, this is comprehensive of those assets.
Okay. Thank you. That's all I have.
Thank you.
Mr. Chairman,
Vice Chair Belzer.
thank you. Ladies, I'd like to thank you for your testimony today. And several witnesses have complimented the commission on granting the pause of 6 months. But I think it's important to note that had the parties, and especially the utility, not agreed to the pause, we would not have been able to grant that due to the legislation that says we have to rule on a rate case application within 6 months. So I think it speaks well of all the parties for working together and proposing the pause, given the unprecedented events that we were seeing with regard to the pandemic. So please understand that the commission certainly recognizes the work of the parties in that pause as well. So that does not go unnoticed. Ms. Hipp, I did want to ask a question about, I know that the general concept is that there's a state provision in the settlement agreement that Dominion would not come in and seek another rate case for rates to be effective prior to January 1, 2024. But there is I reckon, a caveat that except for unforeseen extraordinary economic or financial conditions. And I was just wondering if ORS had any indication of what type of events that might include, which may necessitate coming in before that time.
One of the things that is facing us is a potential for a tax change on corporate entities. And so we wanted to make sure that if the federal government changes the tax rate that would impact Dominion, that there would be a path forward prior to the January 1st, 2024 timeframe to make an adjustment if the company felt that was required. Other unforeseen circumstances could be some sort of clean energy requirement that may come down in the intervening timeframe. But we have included a provision specifically to cover any sort of tax change that might occur.
And I know you're not an attorney, but you are very familiar with the statutes governing rate cases, are you not?
I am.
And absent an agreement by these parties, the commission could not order a utility to stay out for any length of time such as this. Is that correct?
That is correct.
Okay. Ladies, thank you for your testimony today. Mr. Chairman, that's all I have.
Mr. Chairman.
Commissioner Thomas.
Thank you. So, Vice Chair Belser mentioned there was discussion about the potential tax increases. And I have a big concern with regards to that too. And a lot of this is just based on what we were hearing from customers and the affordability issues and things of that nature. And I mean, there is a lot of talk going on these days about tax increases. And I guess I would just hope that the parties to this proceeding could be working together to try to influence that. I know that's a political thing. Maybe it's none of my business to even be saying this. But just given the concerns that we heard from customers, I mean, this could just turn around and basically almost undo everything that you all have accomplished, as I'm sure you know. I mean, they're saying stuff about an international tax increase, not a tax increase, but anyway, like a provision that would keep the countries kind of on even footing, which, I don't see how that would impact Dominion. But they're also talking about some carve-outs there for industries. They're talking about carving out financial institutions. And I think, can't remember what they call it, mining companies, extraction, something to that effect. And to me, we're talking about getting back to the U.S. and a tax increase. We're talking about essential services and people that don't have a choice, who they receive these services from. And I'm just concerned and hopeful that perhaps there are people working behind the scenes to have some sort of a carve out for providers of essential services. Any thoughts on that? Any comments of any of the organizations working on those sorts of things behind the scenes?
Well, it's my understanding that I'm not an attorney either. I'm a social worker, and I go into people's homes who use electricity. And so that's why when AARP stepped up to the table, it's so exciting because it's something I'm passionate about, that how do we protect that group? And it is my understanding that a lot of thought, a lot of effort has been put in place, and there are some checkpoints to ensure that that does not happen. And I think it's exciting. You'll hear from some of the other testimonies or the witness statements that will follow, that concern remains with us. But we don't have all the answers, but this is the giant step forward. And we're hoping that with the support of you and your fellow commissioners, that we will be able to then start realizing how this has value to all of us and to those people who you were just talking about and I deal with every day. Thank you, Commissioner Thomas, for raising that concern.
Thank you.
You are speaking to the right person because she is able to lobby, whereas the ORS is not able to lobby or advocate in the manner that you have discussed. But as you know, we continue to implement the 2017 tax change, which was beneficial to customers. It is a slow process to implement any sort of tax change. And there is the ability for the commission to have a say in any sort of tax change mitigation. So you'll have that opportunity should the company choose to invoke the provision in the settlement agreement to come before you, or in a subsequent rate case should taxes occur. But today, taxes are where they are. We're concerned about the tax change as well as you are. And one of these stakeholder processes on affordability may be able to address that for those that need it the most.
Okay. Yeah, and so, that makes me think about the unprotected excess deferred taxes and the significant part that that plays in keeping the bills lower. I just hope that there will be a way to communicate that to customers where it is, I don't know, meaningful, I guess is what I'm trying to say. And because to me, that is money that already belongs to the customers for sure. And it's kind of like we're talking about it like it's a reduction to the increase, and it is and it isn't. It keeps the bills lower, but they're getting back their money, and they're getting it back faster than they otherwise would have. So I hope there's some meaningful communication in terms of how does that show up on the bill or public relations. I don't know. But that's just another concern of mine.
It will be a separate line item, separately identified on the bill, Commissioner, such that customers can see that. When you talk with customers about EDIT or the tax timing differences, that is a complex issue, and we'll be glad to work with the company to determine how to identify that clearly for customers.
Very good. Thank you.
Thank you.
Commissioner Caston.
Good morning, and thank you, Ms. Hips, Ms. Myers, and all the other folks that have testified. It sounds to me, certainly, that you and Ms. Myers and the others have think and embraced this stakeholder process or this process that occurred. Is that a fair assumption on my part?
Definitely. The process that we used during the 6-month time frame to negotiate the settlement was one, as you have heard, filled with good faith negotiations, creative thinking, and dedication. And I have been part of the settlement process for more years than I would like to claim here in the utility space, and this was one of the most constructive negotiation processes that I've been able to partake in.
And you believe it was in the customers and the public's best interest, this process and the outcome?
I do, yes.
I do as well, Commissioner.
Do you think there's the potential in the future with whatever comes up, whether it's Dominion or whatever utility, that there still may be disagreements and everyone not agreeing with all the facts before them?
I don't have a crystal ball, but I would fathom that there will be times where we will appear before you and we will not be in agreement. You have seen those coming before this case, and I'm sure you will see them after.
That said, and I would not be shocked by that either, that said, would it seem reasonable that perhaps there may be opportunity to do similar stakeholder efforts in the future?
Yes, if we have willing partners. One of our primary objectives as the ORS is to facilitate dispute resolution. You have to have willing partners in order to do that on both sides of the fence. In this case, we were very fortunate to have groups of individuals dedicated to looking for the best outcome for customers.
Very good. Thank you very much. Thank you, Ms. Myers.
Thank you, sir.
Ladies, I have a couple questions for you. I'm looking at paragraph 20 of the settlement agreement, page 10, and it reads in part, DESC commits to give up to $30 million from Dominion Energy shareholders as follows. I'm interested in the up to language. How will we determine, or how should the commission interpret that? Is it a hard $30 million that's available that will be used, or will the settlement agreement require Dominion to report back so we will know how much money was actually given?
Yeah, I'll be
How would
glad
that
to-
work?
Yeah, I'll be glad to take that. The up to 30 million piece is specific to the up to 15 million in arrearage forgiveness funding from shareholders. And the company, the language there infers that the company, at the time that the arrearage forgiveness begins, in accordance with the settlement agreement, may not have $15 million of arrearages that qualify under the terms of the settlement. So the 15 million funding for energy efficiency upgrades and then critical health and safety repairs to individuals' homes is a hard number. But the arrearage forgiveness is flexible, 15 million or under, depending on those that qualify. I believe in the last report that Dominion provided to the commission based around the June 30th timeframe, the amount was slightly less than 15 million. So that's where you see the flexibility. In terms of reporting to the commission, the final results of the arrearage forgiveness, I'm certain that the company, ORS and the stakeholders would support that type of filing. We can do it either in this docket or we can do it in the COVID-19 docket that you have open, the 2020-106A docket.
All right. So if I'm understanding you correctly, that sentence could also mean that 15 million. If there are $15 million in arrears, then Dominion will pay $15 million.
That's correct.
Got you. And that's for all customer classes, right? It's
That
not
is.
okay. It's pretty good. So further down, it talks about the South Carolina. I'm still in paragraph 20. South Carolina Office of Economic Opportunity, assuming that it can accept the funds without threatening its federal allocation of weatherization assistance program funds. So essentially, the flexibility there, if I'm reading it correctly, if they can accept it, they'll get up to 15 million. But if not, the same amount will be given to some low-income energy efficiency program.
That's my understanding. There is some concern that by providing the OEO with these funds, that they would somehow have to receive less in their LIHEAP and weather assistance protection funding from the federal government. We certainly don't want to do that. We don't want customers to receive less of those benefits. It appears that the company would either seek out another community partner, because that's the most efficient way to reach those consumers most in need, or would embark on that on their own. They have a very robust department that works with their customers directly. And so it does provide for that other avenue in the event that OEO says, they'll have to give up federal funding to make room for this.
Okay. Do you know the dollar amount on the transmission costs?
I don't know it off the top of my head, but I am sure that Mr. Kassiam can give that to you when he takes a stand.
Okay. Do you know if any of those costs are associated with the failed VC Summer and nuclear plants?
No, sir. They were built by agreement under the settlement agreement. That transmission was built originally to support VC 2 and 3, but through the direct testimony and the compromises of the settling parties, we have agreed that that transmission is currently utilized to support current customers and will be utilized fully in the future.
So is that a yes or a no? Or are any part of those transmission lines associated with VC Summer Units 2 and 3?
The transmission lines were originally spec'd and planned for two reasons. One, to support VC Summer 2 and 3, and the second, to support customer growth throughout the system in order to provide continued reliable service. With the abandonment of VC Summer 2 and 3 and the increased growth in South Carolina along the company's system, the transmission lines are going to be and are currently utilized to provide service to customers.
Okay. Paragraph 31, page 13 of the settlement agreement, the last sentence reads, the parties agree to use reasonable efforts to defend and support any commission ordered any commission order issued approving this settlement agreement and the terms and conditions contained herein. Ladies, are you familiar with that term of the agreement?
I am.
Okay. Who from ORS is going to defend the commission's approval of this settlement agreement?
I would imagine it would be the executive director and our attorneys.
Okay.
That's to, and if in anticipation there's some sort of appeal or challenge outside of the comprehensive settlement agreement, we don't. We would have the obligation, and the parties would, including the company and any of the stakeholders, to defend the commission. And I'll let my attorney Bateman correct that if that is incorrect, but not being a lawyer, that is my understanding.
And Mr. Chairman, while not on the witness stand, that would be my understanding as well.
Okay, so you mean if any party challenges this settlement agreement, then it would be a legal defense? Is that what I'm hearing? I didn't read it that way.
Yeah,
but
to the extent that we're required, we don't anticipate any party challenging it, Mr. Chairman. As you have heard a number of times, all the parties, it's a unanimous settlement agreement.
Mhm.
The only party not a signatory, CMC, has explicitly let us know that they don't object to the settlement agreement.
Mhm.
So we would not anticipate any legal defense being necessary.
Right. Neither do I. I'm referencing public ridicule or criticism about approving the settlement. For example, I'll play prosecutor, and hopefully you all can play defense attorney. Why in the world would the commission approve a settlement agreement that includes any cost associated with 2 failed nuclear plants? What's the defense?
I believe I just gave it. You know, 2 things, Chairman. One is there was some impact to the capital structure and the cost of debt that trailed through coming off of the abandonment. ORS removed that in our adjustment. The company has agreed, and so have all the stakeholders. And that cost of debt is reflective within the comprehensive settlement agreement. Secondly, on the transmission line transmission issue, I believe my answer was clear that it was built for multiple purposes. When VC Summer 2 and 3 were abandoned, the transmission also supports the provision of high quality, reliable service to all parts of the company's service territory.
If you would like to answer, you can't. You don't have to. But
Well, I'm not able to answer because now you're in the weeds, and I was not in those weeds for the last 6 months. I have read it since and have to rely on Andrew and Ms. Hip and others who do have a better understanding. But I hear your concern, and I think that the settlement is a better deal than just getting stuck on that one point. Because, you know, that was a hot button for consumers, for myself, and for others about VC Summers. But nonetheless, I think that where we are this is a giant step forward, and we began somewhere.
hold on for a second, Miss Myers. I'm hearing. I don't know if that's background noise or someone has a hot mic.
Your Honor, maybe that's me. I apologize. This is John Kaufman. I was just going to make just a brief statement on behalf of AARP on that point, if I may.
If Ms. Myers is finished with her point.
I am. I yield to John.
Go ahead, sir.
I know I'm not, this isn't testimony, but as you know, AARP has been very critical of the decisions made by SCE&G regarding the VC Summer plant and the way that it has been charged to customers. And but as to this settlement, we view this as an overall package, and we're not necessarily saying that any particular provision in isolation is reasonable. And I can understand how someone might say that maybe that transmission piece was related to the nuclear power plant. There are disagreements about it, but we're here today saying that the overall package here is extremely reasonable. This particular rate increase and this settlement is a comprehensive way that it really does serve customers. And hopefully that helps.
Oh, it helps tremendously. I just want to make sure that I see this almost as an indemnity. So all I'm saying is this. I want to make sure my understanding is correctly. If we approve a settlement and the bottom falls out, my anticipation based on this sentence is that every party that's a signatory to this settlement is going to be on every social media platform, every TV news station supporting what the commission did. Now, if that's not my understanding, let me know. That's all I'm asking.
Your understanding is correct.
All right. Commissioner Caston.
This is probably more a question for Dominion, but since we've breached the subject on the transmission line, and all this stuff would tie together, I would think, the IRP, transmission lines, distribution lines, all that stuff looking down the road. If I were building a water treatment facility, typically, they're kind of close to where the water source is. But coming out of that plant, I've got a pretty big line because I've got to get all the water to all my customers through that big line. So I suspect this is kind of that way. That said, I also suspect it's a perfectly good transmission line. It hasn't rotted in the last few years. It's still good. Since the line's there and it's good, am I hearing that, okay, for customer growth, it can still be used? I have not heard or haven't understood yet that the site is the site, where the nuclear facility is. The transmission lines are coming from that direction. Is it safe to assume, or should I maybe not phrase it that way? Somewhere down the road, it's possible, whether it's one of those modular nuclear reactors or some other type generation, if the property is there, if it's available, does it make sense that that site could or would be used for potential future generation?
I think I will defer to witness Kassam to talk about the company's future plans with the site. Again, part of that site has been transitioned to Santee Cooper, along with all of the property. On that, I don't know if the company has any intentions with the remaining pieces. It is contiguous to their other nuclear plant, the original VC Summer nuclear plants. However, the transmission itself is currently providing benefits for customers. And as Attorney Kaufman stated, that was an item of considerable dispute amongst the parties. And the parties have compromised on that. What is clear to us in support of the settlement agreement is that the transmission is used and useful, and it will continue to allow for economic development, growth, customer growth, integration of any renewables. And if there are future generation needs that the company discusses through their IRP down the road, it would be supportive of that.
Thank you very much, Ms. Hill.
You're welcome.
Any more questions for this panel? All right, hearing none. Thank you very much, ladies.
Mr. Chairman, I have just real brief redirect.
Take your time.
Hopefully to provide clarity.
Take your time.
If that's permissible.
Yes, sir.
Commissioner Williams, you asked a question earlier about paragraph 21 and the low-income stakeholder process. And I wanted to read a sentence out of that paragraph and just ask if Ms. Hipp could confirm that sentence is accurate. Ms. Hipp, this is the second to last sentence, and I believe it says, Desk will open a docket at the commission, and all information from stakeholder meetings will be filed in such docket. Is that correct?
Yes, thank you.
Thank you, Ms. Hip. And Ms. Hip, you also were asked a couple of questions by Chairman Williams. I wanted to read a sentence out of paragraph 31 and make sure that I'm reading that correct. The parties agree to use reasonable efforts to defend and support any commission order issued approving the settlement and the terms and conditions contained herein. Is that correct?
That is correct.
Thank you, Ms. Hip. And then one last question. The settlement agreement accepts all ORS dollar adjustments with the exception of the proposed ROE and capital structure. Is that correct?
That is correct.
Okay. Thank you, Ms. Hip. No more redirect. Thank you, Mr. Chairman.
All right, if there's nothing else for these witnesses, ladies, you may step down. Thank you. And we're going to take a 10-minute recess to sanitize the panel. Good morning, ladies and gentlemen. Thank you for joining us here at the Public Service Commission of South Carolina. We're here in docket number 2020-125-E. Let's take roll. Present in the hearing room, we have Commissioners Thomas, Powers, J. Williams, Caston, C. Williams, and Belzer. Joining us virtually, we have Commissioner Urban. Our next witness is from Walmart, Ms. Perry. And she's joining us virtually. Ms. Perry, if you would take the stand.
Yes, I'm here.
If you'll raise your right hand, please. Do we have her on?
Ms. Perry?
I'm having a hard time hearing if someone, I heard her say raise your right hand, but I didn't hear anything after that.
I think we don't, I don't think that's Ms. Perry. That's Ms. Eaton. There's Ms. Perry. All right.
Thank you.
Oh, okay.
Can you hear me now?
Yes, I can.
Okay,
Sorry.
great. You're fine. Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good morning. Would you please state your name and business address for the record?
Yes, my name is Lisa Perry, and my business address is 2608 Southeast J Street in Bentonville, Arkansas.
For whom do you work and in what position?
I work for Walmart as a senior manager in the Energy Services Department.
Have you testified before this commission in prior dockets?
Yes, I have.
And did you cause to be prepared for docket 2020-125E pre-filed settlement testimony dated July 7th, 2021, consisting of 6 pages?
Yes, I did.
Do you have any additions, updates, or corrections to your pre-filed settlement testimony?
No, I do not.
And if I were to ask you the same questions contained in your pre-filed settlement testimony today, would your answers be the same?
Yes, they would be.
I move that the commission accept Ms. Perry's pre-filed settlement testimony into the record as if given orally from the stand.
Ms. Perry's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Ms. Perry, did you also cause to be prepared for docket 2020-125E, one exhibit to your pre-filed settlement testimony consisting of 5 pages and identified as LVP-1?
Yes, I did.
Do you have any additions, updates, or corrections to exhibit LVP-1 to your pre-filed settlement testimony?
No, I do not.
I further move that the commission accept Ms. Perry's exhibit LVP-1 to her pre-filed settlement testimony as the next hearing exhibit.
Ms. Perry's exhibit will be marked as LVP-1 and entered into the record as hearing exhibit 39.
Thank you. Ms. Perry, have you prepared a summary of your pre-filed settlement testimony for us?
Yes, I have.
Would you please read that for everyone, for the parties and council and the commissioners?
Yes. Good morning, commissioners. My name is Lisa Perry, and I am a senior manager in the Energy Services Department for Walmart. On behalf of Walmart, I thank the commission for the privilege of participating in this docket and for allowing the parties additional time to work on and reach a settlement in this case. I also thank the parties for the tireless efforts made by everyone to resolve issues that are as diverse as the parties involved. The primary focus of my direct testimony filed in this docket was on 2 issues: Dominion's requested return on equity of 10.25% and the rate design of Dominion's proposed storm damage component rider. Throughout this docket, Walmart has actively participated in the settlement discussions with other intervening parties and Dominion that led to the comprehensive settlement agreement that is before the commission today. On July 7th, Walmart filed my settlement testimony in support of the settlement agreement. Specifically, and as discussed in my settlement testimony, Walmart believes that the 9.5% return on equity with a capital structure of 51.62% equity agreed to by Dominion in the settlement agreement is reasonable when considering the 9.5% return on equity awarded by this commission to Duke Energy Carolinas and Duke Energy Progress in 2019, and the national average authorized return on equity for vertically integrated utilities, which, as stated in my settlement testimony, has dropped from 9.71% when my direct testimony was filed to 9.64% as of June of this year. My direct testimony also addressed Dominion's proposed storm damage component. As part of the settlement agreement, Dominion has agreed to withdraw its request for the rider and thus renders Walmart's issues with this rider moot. This completes the summary of my settlement testimony, and I respectfully recommend to the Commission that it approve the settlement agreement.
Mr. Chairman, Ms. Perry is available for questions by the commissioners.
Commissioner questions for Ms. Perry.
Mr. Chairman.
Commissioner Thomas.
Thank you. Thank you, Ms. Perry. Appreciate you being available for questions. My question really is in connection with the capital structure and the return on equity. And do you believe that that does sufficiently balance the interests of the ratepayers and the shareholders?
Yes, I do.
And so I was looking at the parent company, Dominion, the parent company, and their capital structure is significantly different. Their equity component is more like 45%, whereas we're looking at 51.62% equity here in this settlement, which obviously is a much stronger balance sheet than the parent company. So basically that says to me that this settlement brings benefits to the company's shareholder and the parent company. It just seems like it's a pretty big difference between the parent company and Dominion in this settlement. I know a lot of things came together to get there, but I guess to me it's a little bit stronger for shareholders, and I just hope that that leaves the company, the South Carolina company, some flexibility, management flexibility to take advantage of that. Any thoughts or comments on that?
Well, from Walmart's perspective, we always balance the requested return on equity with the percent equity in its capital structure. And, that's when we agreed to the settlement agreement and we looked at the 51.62%, we look at that alongside with the 9.5% return on equity. And, based on my experience appearing before other commissions around the U.S. is that, the return on equity and the percent equity is almost starting to act like a sliding scale, right? Where the return on equity seems to tick down a little bit. And then the capital portion of the equity portion of the capital structure starts to tick up a little bit. And so when we looked at the two together, we feel like from our perspective that it is reasonable.
Okay, thank you. That's all I had.
Commissioner Powers.
Ms. Perry, would it be fair to say, though, that this return on equity is higher than the national average?
No, I don't believe it is higher than the national average. I believe it's probably right around the national average.
I just trying to read the charts. It appears to be close, but it is a little higher. Is that correct? It's a little higher.
Yes, that may be. I do know it's very close, though. Maybe a little high, a little low. It could be a little bit high.
Okay, thank you.
Any more questions for Ms. Perry? All right, hearing none, Ms. Perry, you may step down from the witness stand. Thank you for joining us today.
Thank you.
Thank you.
All right, it appears we've come to our last panel for the day, Dominion Energy, South Carolina.
Mr. Chairman, the company calls Rodney Blevins, Alan Rooks, and Keller Kassam to the stand.
All right, gentlemen, please take the stand and pause to be sworn in by our court reporter.
If you'll raise your right hands, please. Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
And Mr. Blevins and Mr. Kassam, if you would help the court reporter out by putting your name tent up so she knows who's speaking, that'll help her out. So thank you for doing that. Mr. Chairman, the parties to the settlement agreement, we've all stipulated to settlement testimony to the record. So I'm going to go ahead and speed things up and move in these gentlemen's testimony into the record. Mr. Blevins has one correction to his testimony, and I want to point that out to you and the other commissioners. If you look at page 3, line 16, the word or should be and that's consistent with the language of the settlement agreement. So that's the sentence that speaks to bills rendered on and after September 1. So with that correction, Mr. Chairman, I would go ahead and move into the record the settlement testimony filed by Mr. Rooks, Mr. Blevins, and Mr. Kassam.
The settlement testimony, the pre-filed direct settlement testimony of Mr. Rooks, Mr. Blevins, and Mr. Kassam will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. And also, Mr. Rooks has 3 exhibits attached to his settlement testimony. That's settlement testimony exhibit AWR 1, 2, and 3, and we would ask that that be included in the record as the next hearing exhibit, and that it be made a composite exhibit, which I think is going to be number 40.
AWR 1 through 3 will be marked as a composite exhibit and entered into the record as hearing exhibit 40.
Okay, thank you, Mr. Chairman. Mr. Blevins, I'm going to begin with you. Would you please state your full name for the record?
Philip Rodney Blevins.
And by whom are you employed and in what capacity?
I'm employed by Dominion Energy as the president of Dominion Energy, South Carolina.
And have you prepared a summary of your pre-filed settlement testimony?
Yes, I have.
Would you please deliver that at this time?
Yes, I will. Morning, Mr. Chairman, members of the commission. I'm here today on behalf of Dominion Energy, South Carolina, to testify in support of the settlement and to discuss why it represents a positive development for energy policy and regulation in South Carolina. First, I want to thank you, the Commission, for pausing these proceedings and giving us the opportunity to negotiate the settlement that's before you today. The Commission's decision was critical to this process, and the Commission's staff should also be recognized for its diligence and professionalism. I also want to thank the ORS for suggesting that we take this approach and the positive role it played throughout the settlement process. The company is grateful to all the parties for the spirit of cooperation, patience, and compromise that they brought to these negotiations. We specifically thank the leadership, lawyers, experts, and support staff of each of these organizations, and we thank the ORS for leading in the process. Reaching consensus on a settlement in this case was a remarkable achievement. It confirms that parties with varied interests can still achieve agreement on matters that are important to utility regulation in this state. If the settlement is approved, the parties will agree to an overall annual rate increase of $61.6 million or 2.86%. That is a 63% reduction from the company's original rate request, net of DSM adjustments. DESC will also flow back to customers on an accelerated basis excess deferred income tax, or EDIT, associated with unprotected property. As of September 1, 2021, the EDIT grossed up for taxes will total approximately $99.5 million. It will be reflected in a decrement rider calculated to limit the overall impact on the rate increase to $35.6 million annually. The rider will end when the balance of unprotected property EDIT is exhausted which is currently expected to occur in 2025. The company will also agree not to file another retail electric rate proceeding absent extraordinary circumstances before July 1, 2023. Dominion Energy will also commit up to $30 million of shareholder funds to programs benefiting economically distressed or vulnerable DESC electric customers. Up to $15 million of these funds will be used to forgive customers past due down balances of more than 60 days as they existed on May 31, 2021. And another $15 million will fund critical health and safety repairs to customers' homes. This repair component of the settlement was the result of a very insightful suggestion made by interveners. The company has recently undertaken a dramatic expansion of energy efficiency programs for low and moderate income customers, which you know. But some customers cannot participate because their homes have critical health and safety deficiencies, things like missing windows, rotten floors, and holes in the exterior walls or roofs. In such cases, installing efficiency measures is unsafe or inefficient until major repairs are made, and these repairs are beyond the scope of what Dominion Energy South Carolina or its DSM program contractors can provide. Under the settlement, $15 million of shareholder funds will be made available to the South Carolina Office of Economic Opportunity to make these kinds of repairs using its existing procurement system and contractors for weatherization work. DESC will also double its annual commitment to the Energy Share program in 2021 and 2022 to $1.5 million, with the incremental funding coming from shareholders. Local community action agencies will use these funds to assist economically distressed or vulnerable customers. For the first time, small general service customers, specifically small businesses, will be able to participate in the Energy Share program, and $500,000 will be earmarked for them. Settlements uniquely allow for the use of voluntary provided shareholder funds for initiatives such as these. Using regulated revenues for programs administered by third parties can be more complicated. The settlement will also provide for a stakeholder process reporting to the Commission to explore an electricity affordability program for Dominion Energy South Carolina's low-income customers and consideration of required legislation. An affordability program can involve discounts to eligible low-income customers on their monthly bills, caps on monthly bills based on income, or arrearage crediting or arrearage management programs. If the settlement is approved, DESC will accept rates based upon an ROE of 9.5% and a capital structure of 48.38% debt and 51.62% equity. With certain exceptions, the settlement rates were calculated based upon the revenue and expense adjustments proposed by the ORS. The company has agreed to these rates with the understanding that the adjustments will not set precedents for future proceedings. Accepted settlement on this basis allows the proceeding to be resolved based upon pragmatic considerations and in a way that might not have been possible otherwise. This rate case is among the last pieces of unfinished regulatory business arising out of the events that resulted in Dominion Energy acquiring the company in 2019. Because its focus was on the nuclear construction, the prior company had not filed a general rate case since 2012, and the Commission's merger order specifically envisioned new electric rates being filed in 2020 to be effective in 2021. In the merger docket, Dominion Energy's late Chairman and CEO testified that as a 200-year-old company, Dominion Energy takes the long view. That remains true here. In this case, DESC is foregoing a material portion of its revenue requirement and other important items it sought in the original filing. The company is willingly supporting a settlement that provides expanded customer benefits at shareholder expense, knowing that doing so allows us to start a new chapter in the history of this company in South Carolina on a constructive, collaborative, and positive footing. Resolving this proceeding by agreement of the parties will be a remarkably positive development for the state of South Carolina at a time when the electric industry is undertaking a challenging transition. Society demands significant progress in reducing carbon emissions, And for Dominion Energy's part, we've set a corporate-wide goal of achieving net zero carbon and methane emissions by 2050. As you know, studies are underway to plan to end DESC's reliance on coal as a fuel, the result of which will require replacing current coal-fired capacity with renewable and lower carbon resources to maintain grid reliability. A plan to do so will need to be created and executed with the involvement of stakeholders and support from this commission. And that's not all. To reduce carbon emissions, industrial production, personal vehicles, and other forms of transportation will increasingly rely on electricity as an energy source. The resulting demands will add to the continuing challenge of meeting customers' energy needs in the rapidly growing coastal and urban areas that we serve. How to time, sequence, and structure the acquisition of renewable energy technologies and the integration of the intermittent and energy-limited storage technologies into the grid is another challenge to be faced in this transition. Protecting reliability will require careful planning and significant capital investment. The abandonment of the nuclear project created a period of mistrust surrounding electric utilities in South Carolina, and that is understandable. But considering the challenges we face today, such emotions will not serve us well going forward. The challenges facing the electric utility industry are simply too great for utilities, regulators, and policymakers to remain divided on what happened in the past. DESC intends to provide a robust response to the challenge of climate change while protecting the reliable and affordable electric service upon which our customers depend. Balancing these goals is a challenge DESC is confident it can meet. We have a successful track record of reliable and cost-effective utility operations, but we cannot meet this challenge alone. Successfully accomplishing the current transition will require cooperation on the part of all who play a role in regulatory and utility matters in this state, and it will require robust and disciplined stakeholder processes, which the company is committed to provide. And ultimately, when all the processes have been completed, utilities must be able to reasonably assume that through regulation they will be allowed to recoup the cost of prudent and necessary investments made to ensure reliable service to customers. This settlement is an important step in a new chapter in the history of the electric industry in South Carolina, and I respectfully ask that the Commission approve the settlement as presented, which is before you without objection. That concludes the summary of my settlement testimony.
Thank you, Mr. Blevins. Mr. Rooks, I'll turn to you next. Would you please state your full name for the record?
Alan Wessinger Rooks.
And by whom are you employed and in what capacity?
I'm employed by Dominion Energy Services as Manager of Regulation for Dominion Energy South Carolina.
And have you prepared a summary of your settlement testimony?
I have.
Would you please deliver that at this time?
Sure. Good morning, Chairman Williams and members of the Commission. My name is Alan W. Rooks, and I am Manager of Regulation for Dominion Energy Services on behalf of Dominion Energy South Carolina, or the company. In my settlement testimony, I sponsor the settlement rate design, which is summarized in attachments B and C to the settlement agreement, and provide the updated retail electric rate schedules for approval of the Commission in this docket. My settlement testimony, exhibit number AWR1, summarizes the rate design being presented to the Commission for approval to include the base rate, the unprotected property-related excess deferred income taxes, or EDIT, decrement rider, and demand-side management, or DSM adjustments, as well as the resulting percentage increases for each of the customer classes. The settlement in this case includes a decrement rider for the purpose of returning to customers in the form of a bill credit the amount associated with EDIT. My settlement testimony, exhibit number AWR2, sets forth the amount of EDIT to be returned on an annual basis and the associated factors for each of the company's retail electric customer classes. This rider expires when the projected $99.5 million EDIT balance as of September 1st, 2021 is exhausted. My settlement testimony, exhibit number AWR3, consists of the rate schedules and general terms and conditions that have been updated to reflect the terms and conditions of the settlement agreement. Page 1 of settlement testimony, exhibit number AWR3, is a contents page listing the rate schedules and general terms and conditions contained in the exhibit that are being presented to the Commission for approval in this docket. Based upon final settlement rates, the monthly 1,000 kilowatt hour residential rate 8 bill would increase from $124.11 today, using May 2021 rates, to $125.92 on and after the first billing cycle of September 2021. This represents an increase of $1.81 or 1.46% of the current 1,000 kilowatt hour residential rate 8 bill. On behalf of the company, I respectfully request that the Commission approve the settlement, which includes the rate design as presented in Settlement Attachment B and Settlement Testimony Exhibit Number AWR1, and the calculation of the EDIT decrement rider presented in Settlement Attachment C and Settlement Testimony Exhibit Number AWR2. Additionally, and finally, I respectfully request that the Commission approve the retail rate schedules attached to my testimony as Settlement Exhibit Number AWR3, which reflect the rates calculated from the settlement rate design and include the EDIT rider. This concludes my summary.
Thank you, Mr. Rooks. Mr. Kassam, would you please state your full name for the record?
William Keller Kassam,
And by whom are you employed and in what capacity?
Dominion Energy, South Carolina, President, Electric Operations.
And have you prepared?
I'm sorry, Attorney Burgess. Thank you, Mr. Kassam.
Can you hear me better now? Sorry.
And Mr. Kassam, have you prepared a summary of your settlement testimony?
Yes, sir, I have.
Would you please deliver that to the Commission?
I will. Chairman Williams and Commissioners, our number one priority is always safety at our company, and I want to recognize Ms. Boyd and the members of your Commission staff here who have probably been here for a few weeks, maybe even at night, but certainly here in the morning, making it safe so we could all gather together. I want to recognize them because they've kind of gone through storm duty themselves, and I think we need to acknowledge that. On behalf of the employees at Dominion Energy South Carolina, I'd also echo your comments about Commissioner Hamilton. I've appeared before him at this commission over 2 decades, and he's always been a gentleman. He was courteous, and he was tough. But the only thing that he exceeded anything in that was the love he had for Ms. Hamilton. And on behalf of my employees, I extend to him our ardent prayers for his comfort and peace during this time of tragedy. I appreciate the opportunity to appear before you today on behalf of Dominion Energy South Carolina and discuss the benefits of the settlement ORS brought forward concerning Dominion Energy South Carolina's continued safety, reliability, and resiliency of its electric system. First, the settlement allows for the company to create a dedicated vegetation management accrual account. Why is that important in South Carolina? In particular, with our service territory, we are zoned for the longest growing season in the United States of America. By taking into account the vegetation management funding, we're able, in this accrual account, you can remove those lead and lags, those ups and downs that occur. For when major storms hit other regions of the country, our contractors leave and they're gone. And then we have to wait sometimes months and a half in order to get them back here on our system to continue our cycle trimming on both our distribution and our transmission. You see, a consistent, disciplined approach to vegetation management annually is a key to safety, reliability, resiliency, and more importantly, that rapid storm recovery like we experienced last week when Hurricane Elsa impacted our coastal service territory. The account supports consistency and will benefit customers through efficiency in planning and managing the work, stabilizing cost, and sustaining reliability in our service territory that, like I will underscore again, has the longest growing season in the United States of America. The company is also grateful to ORS for recognizing Mr. Brasino's surrebuttal testimony that hourly vegetation management expenses are not included in the accrual account. Why would you need to spend hourly? Take, for example, a forester goes in and cuts a big tract of woodlands. And what do they leave on the property line? these spindly trees that are hanging up there that aren't protected from the rest of the wood line. And what's on the other side? One of our transmission lines. So we need to be able to go in and maybe not take the time to bid out that work, but from an hourly standpoint, negotiate with someone to go in there and remove those trees so that it end up causing outages. The settlement also affirms and updates the existing turbine maintenance accrual account, which provides consistent and dedicated annual accrual for the expense of steam turbine maintenance, mainly in our natural gas-fired turbines. This maintenance is critical for maintaining the efficiency and reliability of these units. The account provides budgetary predictability, which allows for long-term planning and efficient contracting for this work. And during the pendency of this proceeding, Dominion Energy South Carolina was able to negotiate a very favorable long-term turbine maintenance contract. That's Jim Miller and the folks in Power Generation Engineering who worked very hard to incorporate all of our combined cycle turbines in this maintenance agreement. And by adding those in volume, they were able to save our customers $4.3 million, which is included in this settlement as well. Good work by that team. The settlement requires Dominion Energy South Carolina to file quarterly reports for its 4 remaining coal units. That's 2 342 megawatt units, water regenerating station down in Lower Richland County. That's also the 600 megawatt coal-fired facility of A.M. Williams down in Berkeley County. And that includes the 400 megawatt facility of Cope in Orangeburg County. Now, that facility is a little different because if natural gas capacity is available, it can be fired 100% with natural gas volumes. In addition to the $1 million for any capital expenditures, we'll provide historic megawatt hour generation and plant in-service balances. It'll be interesting to look at the historic megawatt hour usage. And I hope instead of just looking on an annual basis at what that usage is, we'll look at when exactly those plants are online and when they are needed most, such as on a 20-degree morning in the winter. These reports will be filed until the commission-ordered retirement studies are complete. This information will provide assurances to stakeholders that investments in the continued safety, reliability, and environmental compliance of these plants are reasonable and necessary to allow them to continue serving customers pending retirement. The settlement removes the company's request to resume pre-funding of the storm damage reserve, although it allows existing deferred balances to be amortized into rates. When there are major storms, and there will be major storms, because this hurricane season is already showing it's going to be a busy one in the Atlantic and Gulf basins. But the incremental restoration cost above $2.5 million will be accumulated in the storm damage reserve account. While the amortization amount will provide some recovery against these costs, the size of the current amortization would not be adequate to cover the potential amounts involved in responding to major storms, as we have Hugo, Katrina, Andrew. The company should be allowed to recover those amounts on a reasonable timetable if and when major storms occur. The settlement recognizes the value of the investments in generation, transmission, and distribution assets the company's made since 2011. Transmission lines are planned years in advance through a rigorous, regulated, and dynamic process driven but not limited to economic development, which fortunately South Carolina has experienced that, generation planning, system needs to include the expansion of renewables. We've also seen that up to 1,000 megawatts of large-scale solar on our system. Population growth, Lord knows we've seen that in South Carolina, that is for sure. Demographic shifts, certainly that, and electric load growth. Today, transmission facilities are built with lighter, stronger, and more compact materials than before, such as steel, and newer facilities support reliability and resiliency because they can handle 2 things. They can handle wind up to 150 miles per hour. We've seen that with the tornadic activity we've had come through our low country last March. And we've also seen it with some of the hurricanes that have come through here as well. Those facilities have performed extremely well. And they can handle those ice accumulations like we had back in 2004, and also when Winter Storm Pax came through and tore up Aiken and into the breadbasket of South Carolina. You know, these transmission facilities and the dimensions for which they are built are good for South Carolina. Because you go below the sand hills and it's pretty much swamp. It's a unique landscape, there's no question about it. And to get in and recover from a major storm in these areas cause a lot of disruption of critical areas that make South Carolina the beautiful place it is from the mountains to the sea. As we learned in Texas, transmission corridors are essential to transfer power reliably and efficiently from generation sites to growing population areas, as well as to the critical national defense installations that we have in South Carolina. Because the federal government now, at their military installations, is all about one word: resiliency. Concerning the generation system, the investments reflected in the settlement include the improvements made to harden our generation resources against extreme cold and wind after the polar vortex of 2014. You may remember those rolling brownouts we had. This investment reduces the chance of winter storm blackouts on our system like those that occurred in Texas in February of 2021. And when that happens, people ask, are you going to send mutual aid down there? And I said, there's nothing a lineman can do. So no, we're not. The settlement also reflects the other investments made since 2011 to support the safety, reliability, and environmental compliance of our generation fleet, as was noted earlier, which has a median age that exceeds 50 years. The settlement also reflects the investments made since 2011 in cybersecurity upgrades to protect our system against events like those that took the Colonial Pipeline out of service earlier this year. Somebody's always looking, somebody's always hacking. They reflect the investments we have made in smart switching devices such as SCADA, supervisor control and data acquisition on our distribution and transmission systems, AMI, advanced metering infrastructure, and thousands of other individual upgrades and improvements to promote safety, reliability, resiliency, and efficiency on our system. The collaborative success of this settlement will benefit the reliability and resiliency of the electric grid going forward. The parties to this settlement are stakeholders who will need to work together in the coming years as we plan for coal plant retirements, integrate additional renewable capacity and storage on our system, continue to expand energy efficiency programs, and conduct resource planning to guide us through the transition taking place in the energy industry towards net zero carbon. As we transition to a more sustainable energy system, we must maintain safe, reliable, resilient, and affordable service. The settlement shows that with the proper leadership, these parties can collaborate on important issues for the electric system. You know, our primary goal, my goal every morning when I get up, is to provide normalcy, security, and peace of mind to our customers and our communities who depend upon us each and every second of every day. Where we can create consensus on complex regulatory issues as we have done here, our ability to consistently achieve that primary goal becomes more assured. The Commission, thank you. You deserve credit for putting us on a more cooperative path by pausing the hearing. I also appreciate the leadership of Executive Director Nanette Edwards and the Office of Regulatory Staff. Not many people know how often we talk every week about the burdens and the challenges that we face, and that communication is critical. And if you understand the daily issues, you'll understand the bigger issues that we face as we go forward. And finally, I'd like to recognize and thank our employees here in South Carolina who are dedicated contributors in the communities where they live. And they're stewards of the prudent energy infrastructure investments that deliver a way of life and peace of mind to our customers, the citizens of the Palmetto State. This concludes the summary of my testimony. Thank you.
Thank you, Mr. Kassam. Mr. Chairman, this panel is available for examination by the Commission.
Commissioner Powers.
Thank you, Mr. Chairman. First, Mr. Kassam, I'd like to say I saw your crew in action recently. I have property down in Port Royal, and a tornado last week ripped right through town, and the response, before I got down there, everything was fixed. So you did a good job with that. I know people a lot of times, particularly being from a small town, you don't hear good things about somebody's children, but I've always made a point of telling somebody when their children did something good, and your children did well.
Well, thank you, sir. It's always a challenge. It's 24/7, but they rise to the occasion, so I'm glad of that. I'd like to say it was scripted specifically for you, but they do that for everybody, so thank you very much.
I know they do. And I would commend Dominion for getting to the table here and having us with a settlement. But at this moment, and I guess my question's addressed to Mr. Blevins, at this moment, this is in fact a proposed settlement agreement, because it's not an agreement until the commission approves it. That's certainly understood, is it not?
That is completely understood, yes.
Okay. Well, my concern last week was who released this settlement agreement to the media, to the newspapers, what meetings were held in order to make that decision, and what was the strategy and purpose in doing so? Was it to box the commission in prior to us hearing the matter, or an attempt to usurp our authority? We've already read in the newspaper that an agreement's been reached, that this matter's done, and people were looking to us last week. Well, you've already made that decision. We hadn't even heard the case yet. Who released it to the newspaper? Do you know who did it?
Oh, well, we as a group did it. I mean, if you look at the press releases, we released one individually that was more targeted to the market. And then but there was another release that was more, that was a broader group that did it. The intention certainly was not to box in the Public Service Commission. The intention was to make sure that that those that are not accustomed to reading regulatory documents could understand what was in it and what was good for customers, rather than having, maybe think of it this way, maybe the intention was not to box you out by having somebody else interpret it in such a way that was different than the parties that very vigorously negotiated this agreement, so that it had we arrived at this point in a situation where everybody understood what our intentions are, and you can make the decision, as you said, you have clearly have the authority to do.
Well, it didn't read that way. Can you see from our perspective that seems premature, that we were kind of stuck with what's already out there ahead of time, and that that it could be read the other way?
I appreciate that now that you bring it up that way, but trust me, it was not our intention to box you in. It was to make sure that our intent got across, because if you don't read this stuff every day, you could come to any conclusion you want.
Well, and that's my point, is the average person who picks up the newspaper doesn't read this stuff every day, and they read it and they think, well, look what the Public Service Commission has done. They've increased rates, and it kind of I don't know. To me, it wasn't a knee-jerk reaction, because I thought about it a long time, but even before about bringing this up to you, it really seemed to put us in an awkward position. And I wonder about in the future whether such press releases would be proper prior to a hearing as to things assumingly already accomplished.
Feedback taken. I'll take that feedback. No ill intent on the part. I'll speak for Dominion Energy South Carolina, but I know how hard we worked to bring this thing together.
And I appreciate that.
I think everybody would. I'm not going to speak for all the parties, but I don't think anybody would have had that intent.
I think the commission appreciates all the work you've done. And it's a whole lot better to be sitting here the way we're sitting here than the way we were sitting here in January.
Amen.
Okay, thank you very much.
Commissioner Caston.
Is it still morning? Yes, it is. Good morning, gentlemen. Mr. Blevins, as I was listening to your summary of the settlement testimony, I heard you mention stakeholder a few times, and I almost thought you were quoting the Apostle Paul for a minute. You were talking about forgetting what is past and looking forward to the future. And I don't think that's what you were doing, but it reminded me of that. So, and I don't want to put words in your mouth, but what it seems I heard was, in essence, you were saying we can learn from the past, but we don't need to dwell on the past. Is that a fair assessment?
That's very well said. We definitely need to learn from the past, but we do need to get focused on the future. Yes, sir.
And, some, actually, four of us, we haven't even been here a year. And I have a high level of confidence that no one in this room, no one listening, no one watching can do one thing about the past. Would you agree?
I would agree because I've, for the last 2.5 years, have been trying to put it back there. So there's nobody that can do anything about what happened other than get it behind us.
Well, as I think about what I think I heard you say, and when you were talking about stakeholder process, it seemed that you were saying not only the benefits of this particular process, but as though this was the shape of things to come. Not absolutely positively on every single thing, but did I read too much into what you said?
I am positioning myself as an optimist on this subject, and I realize you could get on the other side of it. If I look back to where we were in January and discussions that happened prior to that that were in the monthly updates the commission received, I would characterize what we had as a trust deficit. Right. So we didn't have the level of trust we needed in order to resolve our differences, and it took 6 really hard months to get there. I think that this settlement is evidence of, this is the optimist in me, that we are have the opportunity to resolve other differences in a more constructive fashion, and they will be tough as well. But I like to think of this as a critical moment for us as stakeholders on utility regulation in the state. Again, we'll have we'll propose, you decide, is the way that works. I'm fully aware of that.
Thank you. And certainly I can't speak for the commission. I can only speak for me. And it may not surprise you to learn that we're not always in agreement on everything. And I've been married 40 years, and I can tell you with absolute certainty that that pretty much occurs almost on a daily basis. And it still works. And I suspect down the road, the parties that are in this room listening and everything else probably still going to have some differences. But if I'm understanding you and the parties that I've heard, there's always a path forward. Always. When you work at it, listen to each other. Everybody's got to. It works best when there is trust. And I think that's what you said, correct?
That's
Doesn't mean agreement, it means trust. I trust my wife. Man, I don't agree with her often. And that's my editorial comment that I probably don't need to put in there. I do appreciate everyone's hard work. Thank you for your testimony.
Thank you.
Commissioner Williams.
Thank you, Chairman Williams. It is a pleasure to be able to read faces and listen to you all directly. And so I just want to add that I haven't met you all individually, but I'm really glad to be able to have this face-to-face time. I also appreciate the discussion about trust and the emotions that get in the way with trust going forward, and feel like this is a new beginning, and as well as the stakeholder involvement that you've all had to get you to this point. But I do have a few questions. Mr. Blevins, or all of you, as I'm learning, with the arrearage funding, do you anticipate this and showing up on people's bills? How do you intend to communicate it? Again, if I'm asking something I shouldn't ask, y'all just stop me. And particularly, how is this program related to the South Carolina Emergency Rental Assistance Program that we recently got an update on?
All right, so I'll first of all, there's a stakeholder process here but obviously we've thought a lot about this, about how to do this. You'll note in there it says more than 60-day arrears as of May 31.
Right.
Okay, so we're pretty sure we know who those accounts are now. We've got a fence around that. And so when the commission, if the commission approves the settlement, we will put a disconnect block on those accounts. Then we'll engage the stakeholders. Get everybody to agree on what the process is going to be, who's eligible, make sure we all agree on that. Good peer check is good in any case. Make sure we agree on that. Then within 90 days, we credit those accounts for the amount that they were in arrears more than 60 days on May 31. There is a communications challenge that is a part of that whole piece, and it's important that customers continue to pay their bill because this is as of May 31 and we're in the summertime and they could continue to accrue balances, get that credit, and still have a balance that was old enough and large enough that they still could be cut off for non-payment. So I think it's important that that's part of the communication, but I'll start there. So we think we have we know who the customers are, but we're going to engage with the stakeholders to do that, to make sure that we have agreement on what that process looks like.
And how does this relate to the federal funding that's coming through and the South Carolina Emergency Rental Assistance Program that is funding some of the utility arrearages?
I would say that's an ongoing process that's based upon a percentage of income. There's a well-established process about whether or not customers qualify, about approval, about the posting. That's a process that has a lot of maturity to it. This is a one-time event. So that's what's different about this. This is completely separate, one-time event.
So the federal funds are in addition to the $15 million that you're talking about?
That's exactly right.
Okay.
This is a one-time event. Now, you're talking about the complexity. One of the things is making sure that you're not double,
right,
that there's not an overlap there. That's requires some careful management, without a doubt.
Okay. Regarding Mr. Belevins's testimony and the coal plants and that it's on page 9 of 13, and you talk about a stakeholder process related to capital projects at coal plants. Is that stakeholder process a part of a separate agreement like the IRP, or is that also a commitment that's being made in your testimony?
I think I'm referencing the coal retirement study. I'd have to look back at the exact page, but I think that's what I'm talking about associated with that.
Stakeholder process and reporting concerning capital projects at coal plants.
Say page 9?
Yes.
I have it.
Yes. I think.
Would you read it for me one more time? I apologize.
I totally understand. Does the settlement include other provisions? And then you say stakeholder processes and reporting concerning capital projects at coal plants.
The capital reporting at the coal plants is strictly about are you asking about the stakeholder process?
Right, particularly related to the capital projects at coal plants. I did not see that as a stakeholder process anywhere else in the settlement agreement, so I'm asking about that particular commitment.
You said it's line, what line?
Line 6.
Okay. For example, there are a number of other specific provisions of the settlement related to cost-benefit analysis for future grid investment plans, stakeholder processes, and reporting concerning capital. Those are discrete. Yes.
Thank you.
Sorry it took me so long to get
No,
there.
no, no, that makes sense, and thank you for that clarification. Now, I'm not sure which of you to direct this question, but regarding the transfer of funding to Santee Cooper, I'm not sure if my number's right, but regarding the BC Summer Units 2 and 3 metered accounts, I'm just curious from an education perspective how that happens, how, not in a deep dive kind of way, but an overall understanding.
Well, I'll take that, Commissioner.
Thank you.
So prior to abandonment, the company and Santee were partners in that project. And so there were a number of meters at that site that supplied power for the various activities that were going on during construction. And then when the project was abandoned, those meters are still in place, and a lot of security activities and site stabilization activities were still ongoing during the early part of the test year. And so that adjustment is made to remove any expenses that were in the company's books and records in that test period out of consideration in this case. And so going forward, Santee Cooper, I believe, is maintaining some responsibilities at the site, and they will be responsible for those costs, and will be billed for those costs. And any cost incurred by DESC moving forward will be taken below the line. And that may be something to maintain a permit, like a water pump or something like that, in compliance with a DHEC permit or things like that. So I hope that helps.
Is Santee Cooper in agreement with this? Do they have a say in this?
We've been in conversations and working with them on this issue.
Okay. Meaning they're supportive of this switch, or can you give me any more definition?
If we're talking about rate making here in South Carolina, and specifically for DESC customers, we're removing those expenses so that South Carolina customers for DESC are not paying for those. So that's what we're trying to accomplish here.
Okay. Okay. Regarding the EDIT decrement, how do you envision describing that? I looked in Mr. Rooks's testimony in the exhibits, and it's identified as EDIT decrement rider, maybe more than that, but as an almost average bill payer, I would have no clue what that meant. How do you anticipate sharing that? Because as some of my fellow commissioners have shared, the concern is that when that goes away, that feels like an increase in your bill.
So yeah, there have been conversations that have been ongoing about how we communicate that. Obviously, excess deferred income taxes that's not a topic that most customers are familiar with. And so we've already engaged our customer service organization. And of course, this is still subject to commission approval. Mm-hmm. But we are looking into what we might call that or name that on a bill so that customers can understand that it is a decrease to the bill. And as the settlement makes clear, it will be shown as a line item so customers will see it. And it will run through June of 2025. And each class's decrement will be applied to the energy on their bill as seen in Attachment C to the settlement. And so we talk a lot in terms of the 1,000 kilowatt hour residential bill, and I believe the factor for residential class is around 0.00158. And so for that particular customer, they would open up their bill and see a $1.58 credit. But you are correct. At such time as that $99.5 million in total is exhausted, that decrement rider will fall off of the bill and will go away.
Thank you. I'm glad to hear that it's not necessarily the words that are in the rate sheets, and just suggest that you all think about a way to show that that's temporary. And you mentioned a date that it would end, but I think both of those are key to know for those that look at their bills.
That's good feedback. We'll take that.
Okay. Thank you. That's it, Chairman Williams.
Commissioner Thomas.
Thank you. It's good to be here in the same room. And once again, I'm just going to say I appreciate all the work that went into this. And also to mirror Commissioner Powers' comment, it's not a done deal yet. And so I just have 4 or 5 concerns. Some of these I believe I would probably categorize as opportunities. And again, I want to get back to the agreed upon capital structure. It is stronger than the parent company. And in my opinion, that gives the South Carolina company some leverage with the parent company to ask for some things. And one of those things could perhaps be more money to help these people that are in arrears, just as an example. But I would like for you all to keep that in mind, that if this is approved, then you're bringing something to the table to the parent company. And, again, that involves communication. There's a lot of this involves communication. And as Commissioner Williams was talking about the refunds of the excess deferred income taxes, I think it's important how that's communicated. And I think another aspect of that too is that it should try to make it clear that this is customers' money that's coming back to them. It's not a reduction in the rate increase. Don't know how you do it. Good luck with it, but it's a topic of concern. Let's talk also about what I was mentioning earlier, the potential for the corporate tax increases. If that happens, then the excess deferred income taxes becomes just the exact opposite of that, not only on the income statement, but on the balance sheet. So, that's a big concern to me. And I do hope that the company and all of the intervening parties can work together to help make sure that that doesn't happen to utility companies. And it's going to put the utility company at a disadvantage to the co-ops in terms of industrial recruiting, which is important for jobs for so many people. So, and again, this kind of gets back to me and being concerned about the low-income customers. They're the ones that are going to get hit the hardest if these things go through. And they're going to see this as a negative on the company and a negative on us. And I just believe that a lot of work needs to go into can there be some sort of a carve-out for the providers of essential services? And I believe that you all are up to the challenge, and we'll work together to do the best you can on that. And a little bit on the polar vortex and the grid hardening. I know that you talked a good bit about that, Mr. Kasam, I think back in January, and in your experience, and so how important that is to you personally, just based on what the company went through back in whenever it was. So do you believe that you all have done everything possible in order to keep that sort of a situation, Texas sort of a situation occurring, plants freezing and so on and so forth?
Yes, sir. Well, nobody controls the weather, that's for sure. I know the people in Texas will probably tell you that. But we have invested $40 million in our generation facilities. And those generation facilities, the majority of them are located on a river. They got wind that comes across that water that feels even colder, and then you start getting ice accumulations. And so with that $40 million, what have we done? Well, we put up windbreaks to block that wind. That'll keep things from, freezing over, coming across that water. In addition to that, we've taken a lot of our enunciators that actually work, that actually give you alarms on different pieces of equipment and tubing that you have in the facility. And instead of somebody having to go out there and read it and look at it, it actually comes into the control room, so it's monitored, and you can monitor the monitoring of it from that standpoint. So to increase that from that standpoint. In addition to that, we increased our design criteria, and we've gone to 0 degrees with a 30-mile-per-hour wind. From a sustained perspective. So it's what you insulate to, and that's what we've tried to do from that standpoint. So we feel like we've taken the prudent investments and the necessary precautions. We've changed our procedures as it relates, and we took the power plants, and when we get extreme cold or extreme heat, we almost go through what we do when we're preparing for a hurricane to come. See it coming? It's on the way. These are the steps you take, day 1, day 2, day 3, landfall. And so we do the same thing at the power plants. Here's the temperature coming, here are the wind speeds coming, where exactly are we going to be vulnerable, and that's something that we've initiated as well. So we kind of learn on the emergency preparedness side for the wire side to incorporate a lot of things on the generation side. And yeah, I hope we don't have to go through what we went through in 2014 again, because there's no question that people depend on us to do better than what we performed at that time. And so our effort since then has been to make sure that that doesn't happen again and we don't let folks down.
Very good. Appreciate that. And another topic that's been mentioned is the cybersecurity. Obviously, that's an important thing too. I guess as a commissioner, a regulator, the polar vortex scenario is, one of the things that concerns me a great deal for sure. And the other would be the cybersecurity issues. Those are of concern to me as a regulator. And I just want to say that, there's difficult things, but very, very important. And hope that the company is making the prudent investments to ensure that that doesn't happen as well.
Well, Commissioner, you'll be glad to know that the former Chief Information Officer, the head IT guy, is now the President of Dominion, South Carolina, Mr. Blevins here. And so we kind of got the head guy that led their effort for 7 years, who is now leading the charge down here. So he's got his mind laser focused on that, and I'm sure that my employees would tell you the same thing, because it goes all the way down to their level, watching what you click on, what you hover over, making sure that no bad person who has ill intent is infiltrating, any of our systems, because there's just too much riding on it. So, Mr. Blevins, I don't know if that's enough of an introduction you want to say any more, but that's it.
Well, I've said a good bit, and I wanted to just open it up to any of you for comments based on what I've said or what anybody else has said. And Mr. Blevins, perhaps I need to take some lessons from you personally on how to behave myself so that I'm protected. But that aside, anything that any of you would like to say?
I was listening to your conversation with prior witness about the possible causes of having to come back in before what's prescribed in the settlement agreement, and we certainly didn't develop that exclusion there with any thought in mind outside the tax change. I like the idea. I'll talk to our federal policy folks, because that's where it's going to come from, about trying to carve out the utilities. That's a really interesting idea. I'll take that and run to our federal policy folks. But we obviously are going to be in the camp of let us run our business and please don't change the tax rate. That's where we're going to be. But thank you for all that. We're just what I would. It hasn't come up directly, so just want you and all the commissioners to know that it was safe, reliable, and resilient electric service is something we take serious in a solemn way. We get up every morning focused on that, and whether it be weather, whether it be cyber, whether it be all threats, we understand that what our role is in civilization and society. Take it seriously.
Very good. Thank you. That's all I had.
Commissioner Caston.
All the conversations caused me to think about a couple other things. I hope you gentlemen don't mind. This whole process, certainly new to me, it's been very interesting. But all I can really speak to are my personal experiences, things I know, things I've learned, good and bad. And I learned a boatload more from the bad. You got to trust me on that. That said, my experience with utility, certainly on a much smaller scale than Dominion. Y'all just had more zeros at the end. But my personal experience was that I never, ever, ever had a customer come up to me and ask me if I would raise their rates. Never did. Never had one say, you're not charging us enough. You need to add more. And I suspect you guys have not either. But personally, and this was just me, I felt responsible for every one of those customers. I felt responsible for everybody that worked with me. I took it very personally, to the point of I was very concerned and interested in knowing and understanding, are we doing this well? Are we doing this right? Are we doing it as best we can? And when I would even talk to our folks internally, I would normally get, yes, we are. And they really thought they were. Because you don't know what you don't know. So I'm saying all that for this reason. I hope that Dominion and any other utility will not be afraid to ask the difficult questions amongst themselves to determine, we often hear the terms best in class. What does that mean? And I know I'm rambling now, but believe it or not, I used to run track at Clemson back when everybody was slow. But one thing about it, you ran against a clock. It was a known, absolute known. There could be 7 heats, but you're still running against time. It's a known. So when we're talking about best in class performance measures, how do you know if you're good? How do you know if you're really doing it well and efficient? And it's a rhetorical question now, you don't have to answer. But how do you know? So I spent a lot of time studying that, looking at that kind of stuff, determining measures, what's important to measure. Because I did learn this, that what you measure, you manage. And until you really know that you're doing it well, you can ask anybody and they'll tell you, yes, generally, because they really believe it. So I'm encouraging Dominion and any other utility to not be afraid to search that, to see, are we doing it the best we can? Because when it comes down to cost and helping ameliorate rates or better control rates, you guys are the primary folks who can do that, not me. You guys. So run it like it was your own. Like your mom was having to pay that bill and your grandma. Now, I don't know that requires a comment. I just provided input.
I will say this. We had a conversation about are you good in January, and I left that conversation thinking, note to file, we're going to bring the metric package next time we need to file something when it comes to cost. Obviously, it doesn't apply here. We do a lot of benchmarking. We don't have because of utilities in a lot of places don't have that competitive intelligence problem. Not only can we benchmark on cost, but we can also get them to tell us why they're better on cost. We do quite a bit of that, but now with having a peer electric territory in Virginia too, we can do it in-house as well. So we're doing a lot of that. I just realized in January when you and I started this conversation, I didn't give you enough information to start with, and that won't happen again. Next time you'll get plenty.
And Commissioner, I'll tell you, I agree with you. Everything's personal. My 86-year-old mama down in Creston, South Carolina, she pays that bill all the time. So I think about her every day when we go out there and do something. You know, our safety record, if you take care of your people, then they'll take care of your customers. And so that's a high bar for us to focus on. We've only had 2 incidents this year amongst our generating and lineman fleet. One lineman got bit by a pit bull through his rubber gloves and his leather protectors, and another person cleaning out fly ash got it down his boot and burned his leg. The other thing is reliability. We focus on that all the time, and there are a lot of things that go into that reliability puzzle, and we were real proud of basically what our long-standing record has been for reliability in our SAIDI, System Average Interruption Duration Index, which is clearly ranked in the top quartile of the electric utility industry, and certainly tops when it comes to South Carolina. So those are 2 major metrics. You can get in the weeds and you can look at a lot of things, but you know what? You can let your employees know you care about them and you love them, and you want them to extend that same courtesy to the customers they interact with every day, because people don't come in here to buy a box of electricity or a bucket of natural gas. We got to take it to them, and we got to go in their yards, and we got to be respectful of them at all times and what they depend upon us. And then if you can keep the power on, because you can take a lot of surveys and you can ask people what you want from a rate standpoint. You can ask people what you want in a services standpoint. And what has been true in this industry in the last 33 years that I've been in it, one thing, when I flip that switch, I want my lights to come on, and I want them to stay on. And that's what we endeavor to try to do as a team each and every day to serve South Carolina. So thank you.
And Mr. Blevins, I was wondering if you would remember that. Apparently you did remember that.
I remember a lot in January. Thank you.
Well, listen, I'm not here to lecture, and I apologize if it sounds like I am. I do not mean to, but what I do know are those things I've learned. And I also learned that comparing myself with my neighbor or the other utilities wasn't always bad, but it wasn't always a good thing. How do I know they're doing it well? They may not be real good at it. So, again, I'm glad you're thinking that way, and I hope you will continue to drill down. Thank you very much. I appreciate it, gentlemen, and I apologize for rambling so long.
Commissioner Williams? Oh, I'm sorry. I thought I saw your microphone on. I was told I was moving a little too fast earlier, so I wanted to slow down a little bit. A couple of things, gentlemen, I'd like to speak with you about. First, I want to talk about leadership. In my experience, a good leader can easily identify an organization that lacks leadership or a situation that lacks leadership, because usually, in my experience, it involves a lack of accountability, a lack of trust, as you all discussed, inability to speak in one voice, low morale, low enthusiasm. And I think it's important to note that I've seen leadership demonstrated during this hearing today in a way that I don't think I've ever seen since I've been on the commission. So I can't really say who's responsible for it. Obviously, Mr. Blevins, you're the president of Dominion Energy South Carolina, and Director Edwards is the leader of the Office of Regulatory Staff. But whoever is responsible for putting together this settlement and making this presentation in this way where everyone has spoken in one voice, everyone seems to be enthusiastic about the settlement, I think is quite phenomenal. to be quite honest with you. And so I definitely believe in giving credit where credit is due. So thank you for demonstrating that leadership and taking this process seriously. Obviously, this is it may not be a one-time deal, but I understand that the concessions made here may not necessarily be made again in the future. I understand that the parties may take different positions on the same matter or same issues in the future, but at least for this particular settlement, I think that the parties did a very good job. Mr. Blevins, you talked about moving forward to the future and looking to the future, and I definitely understand that, and that's what we want to do. I will just share with you that while simultaneously looking to the future, I think it's important, at least for the commission, to remember the terms and phrases "never again" and "never forget" that we use to refer to tragedies like 9/11 or the Holocaust or Pearl Harbor. Not to dwell on those negative periods of history, but to remember that they happened and to ensure that they never happen again. And so obviously we know that we had a horrible tragedy in this state with the VC Summer Units 2 and 3. And I know that we never want to go through anything like that again. And so I think it's important for the commission, at least in my opinion, whenever we get settlements or we hear rate cases or anything that comes before this commission, that we properly vet what's presented before us, that we're on the same page about what the parties are saying. And so that leads me to, and I think that's a necessity, because if we don't fully understand what's being presented to us, it's hard for us to make a full and accurate decision, because there just may be confusion about what the parties are saying. So here, considering that all the parties are in agreement, I just want to make sure that I understand what's being presented before us. I want to talk about the transmission lines. Now, Mr. Rooks, I think a witness who testified prior to your testimony said you would be the best person to ask about the dollar amount associated with the transmission lines. What's the dollar amount? I seen the settlement is 100% of transmission costs. How much money is that?
We checked during the break, it's about $350 million, Commissioner.
Okay. And what percentage of that $350 million is associated with the failed VC Summer plants, units 2 and 3?
I'll take that, Mr. Rooks. When you do transmission planning, everybody thinks that you can just go out linear. Commissioner Caston, like the water plant, you got flowback valves on your water lines. You don't have that on electricity as far as where it flows. And so when you begin, you don't plan transmission for one generating facility, not even one as large as that. And keep in mind, you've got 1,200 megawatts of generation that's in that particular area as well. And so when you start looking at transmission, it wasn't like we went across a green field and we just built brand new poles, put brand new poles in the ground. Of that 550 circuit miles associated with a number of transmission projects, and we broke it up into 30-something different projects. Only about 5 miles of it was greenfield right away, and that was in Richland County coming down to the Killian substation. And so I talked a little bit in my summary about all of the dynamics that go into planning transmission years in advance. We're having transmission planning meetings right now over the integrated resource plan and coal retirement. You have to do it 10, 15, 20 years in advance. You just have to. If you wait till the last minute. And so therefore you've got to make some assumptions. So you've got that planning window that is very long. In addition to that, you've got to look at your existing load, because you had the blackout that we talked about up in the Northeast back in 2004 when, 50 million people sat in the dark up there. And so the FERC came out and said, you will have planning criteria that give you enough room. Everybody talks about capacity of these transmission lines, like they need to be a water hose that's filled up all the time. That doesn't happen. It doesn't happen. It's like a water line. If you get up in there 100%, you better be putting in some loop system and things of that nature. So when you look at these lines, if you said, well, what's the percent associated with VC Summer, as if to go take one of the lines out of service or to pull one of the poles out of the ground, you can't. It's energized. There are electrons flowing on them, and they benefit the system. You talked, Commissioner Caston, about long-term service with your wife, and you're going to have arguments back and forth and things of that nature. Well, one saying that I've always heard coming up is you don't throw the baby out with the bathwater. And I will tell you, we looks back and we say, oh, well, let's look at anything that's nuclear, any way we can associate it with that, and let's reject it. And I'm saying don't throw the baby out with the bathwater. It was built on schedule, and it was built slightly under budget. And it is the one thing that comes out of all that chaos that is beneficial to the state of South Carolina. The dynamic process we go through in planning transmission, for example, 1,000 megawatts of renewables that are on our system today that we didn't even know were going to be on our system back then. Guess what? It helped accommodate them on our system. All of the load growth and the population demographics and the shifts that we have had throughout South Carolina, and everybody coming down here, and the growth we have on the coast, and the fact that you don't have any generation that's on the coast. We don't. You've got to bring that generation from VC Summer 1, from Columbia Energy Center here in Columbia to be able to get down and serve that load. So it's a dynamic process that you can't tie to units 2 and 3 of VC Summer. It is part of the system. It's used and useful. You can't go in and demarcate out any particular wire, foot of wire, or pole and say, oh, well, that's not providing benefit to the system today. It all does, and it will continue to provide that benefit. And with all of the scrutiny that we receive from going in and having that facility in play, I'm glad we got it. Because when all of these Matthew, Elsa, and all of these storms that come through, all the icing requirements and everything that comes through, these units and these structures are impervious to it. And they provide that reliability that we come to anticipate. So there's no way we can go in and cut up the pie and say this part of this line or this wire is associated with VC Summer. It's tied to the regional grid. It's tied to Duke. It's tied to Santee Cooper. It's tied to the old Progress system. And in all of those places, it is providing tangible benefits for the state of South Carolina. It is an energy corridor that is much like, I assume, when I-26 was first built, because it kind of parallels it. And it provides immense opportunities for South Carolina from an economic development standpoint, a population growth standpoint, new generation standpoint, and then that resiliency and safety that is required that our customers expect. It's used and it's useful.
Mr. Sam, I appreciate your passion. I just want to make sure I understand your answer. Is your answer to my question is that you can't tell, or you can't make that calculation as to how much should be attributed to VC Summer 2 and 3? Is that?
I'm telling you that the dynamics of the system and how the system has changed since then, since it was first planned, since it was first brought on, and all the other transmission projects that had to be done in conjunction with it and absent it, and how dynamic that system changes. It changes every day. That I assume some engineer could go back in and do a deep dive, but I'd not have 100% confidence that they could actually produce for you what percent or what cost is associated with those plants that were not built based upon the use of that infrastructure today to benefit the system and our customers from a safety and reliability standpoint. I hope that's clear, sir.
I think so. So it could be done. It would just take a deep dive into the weeds to do it. And even then, you don't know if it would be accurate or not based on where we are today.
Yes, sir. All I can tell you is I get in the mornings and I watch the generation report and I look at the loading that we have on our system every day. And I know that without even units 2 and 3 being constructed, I know that those lines are an integral part of us to safely and delivering reliable energy to our customers. We didn't tear, we actually tore down the transmission that we have. We didn't build it on a green field. We uprated the lines that we had to begin with. We might have gone with a double circuit 230 on both sides. We might have gone in and put a 115 to the side on steel structures. It took up less room within the right-of-way because we went with steel instead of wood. And I'm saying that it is an integral part of our system as it exists today. And if you went back and tried to do that benchmark and measurement, you'd play heck pulling all those needles out that haystack so you could just assign exactly what's out there in steel and aluminum to those two units that were constructed were to be constructed in Jenkinsville.
All right. I want to point the panel to page 13, paragraph 31, last sentence. I asked an earlier panel this question about the meaning of the last sentence in paragraph 31. The parties agree to use reasonable efforts to defend and support any commission order issued approving this settlement and the terms and conditions contained therein. I'll start with you, Mr. Blevins. What does that sentence mean to you?
It means that we were all going to come in here, for instance, the unified front you've heard here in support of this settlement is the same posture that we'll have externally.
If we were to approve the settlement.
If you were to approve the settlement.
All right. Thank you. All right. I don't have any further questions. Commissioner Caston. Commissioner Caston.
Man, I hate to bring up this transmission thing again, but I wanted to see if I understand.
It don't matter. I've lived it for a long time, so go ahead.
You were saying 500, I heard 550 miles of transmission.
Circuit miles, yes, sir.
Okay.
Keep in mind, it's got 3 phases, 3 wires on each structure, so if you walked it, it wouldn't be 500, but if you multiplied the wire by 3 and threw some static in there, you get to it.
All right, so if I was running pipe and it's not 3 phases, just one pipe, would it be 550 divided by 3?
It'd be close to it. It might
Okay.
not be exact. You try to confuse me with that water analogy now, but I know you can't help it any more than I can the electric, but it'd be close, yes, sir.
And you said there were 5 miles of greenfield. In other words, you're saying that of all of the transmission lines, only about 5 miles of it was physically new, put on new rights of way, new structure, new lines.
It was, I want to be clear on that. The 5 miles was what we call greenfield, meaning it was bare ground. There was no electric transmission right of way that went through it. We had to acquire that right of way. We had to go through settlement process in order to be able to achieve that. And then we came back in once we did that, put the caissons and the foundations in the ground, set up poles, strung wire. On the other rights of way, there were already existing transmission lines. The majority of them were H-frame wood, the ones that looked like suspenders, and they spread about 26 feet. We went in, rebuilt those. A lot of them were what we call double circuit. You've got a monopoles, big steel poles sticking up about 123 feet in average height, and we've got double circuit on either side. So you got insulators that hang down in 3, and it's good to go. If you go over here to the zoo, when you're going in 126 into Columbia, you look right over there, you'll see a great big old angle structure right there, and it perfectly gives you the view when it goes back across the Saluda River up the hill going towards Langston Hospital. That's typical what everything looks like if you go right there. But that's a big old angle structure there, and it's chipped in about 36 foot of granite rock. So, but that'll give you an idea of what it is. So that's greenfield right of way, and then where we redid right of way, where we actually had to go, and it actually made the job tougher. Can you imagine going out there with 230,000 volts and you're working in the same right of way with a Manus crane up in there? And then that's why we had to break it down into 30-something projects, because system control, due to FERC requirements, they only let us out on that right of way doing work at certain times. And so it was a monumental chore, and those folks, they did a heck of a job.
Understand. So as far as that approximate 5 miles, is it safe for me to assume that 5 miles was specifically related to VC Summer, or not necessarily?
No, sir, it's not, because it had to get into the Killian substation.
Yeah,
If you
okay.
go up to the Killian substation, it's in northeast Columbia, where we had the majority of growth in Columbia within the last 10 years, northeast Columbia. up there in all those areas. So you have to take in consideration all of the population growth and everything you see. You look at those distribution breakers, you find out how much they're loaded up in those substations. That rolls on up to your sub-transmission, and that rolls up to your 230 kV. So no, sir, not even on, and that's a great point. Not even on the virgin new right-of-way you had out there that was greenfield can you make the assumption, oh, you built that for the power plant. You know what? We even had a study with an economic development prospect that was coming up into that neck of the woods long before they started with VC Summer, and we were going to have to build a transmission line up there and uprate that substation. That was even before VC Summer 2 or 3. So it just goes to the point. You can't just take in one thing, not generation, not transmission, not interconnections, not population shift, not load growth. You got to take it all into consideration when you're out there planning transmission. Over a long period of time, as you well know, 50, 100 years is what you plan water stuff for.
If you're good at it.
Yes, sir.
Okay, I think that pretty much answered my question. In essence, there were upgrades. Some of the existing infrastructure towers replaced some, already had wire on it, upgraded some of the wire. And independent of, you're saying, if I'm understanding, independent of whether a new facility was going here or not, upgrades were going to occur because of growth and future demands and everything else.
Yes, sir.
Is that what you're
That's
saying?
correct. Yes, sir.
All right, well, thank you very much.
Yes, sir.
All right. I don't think there are any more questions. Attorney Burgess?
I have no redirect, Mr. Chairman, and I would ask that these witnesses be excused from the settlement portion of the hearing as well as the remainder of the hearing this afternoon.
All right, gentlemen, thank you for your testimony. You may be excused.
Thank you, Mr. Chairman.
Thank you.
Mr. Chairman.
Commissioner Urban.
Mr. Chairman, before the parties leave, I'd like to thank everyone that participated in these 6 months of negotiations. I think that it's obvious to us all that they worked extremely hard in trying to reach a unanimous settlement agreement. And I think they've done a very capable job of explaining the various details to us, not only in their testimony today, but in their pre-file testimony with the commission. And this is a reset, I believe, for Dominion. It's something that Tom Farrell would have been proud of. You know, the 4 new commissioners never had an opportunity to meet Mr. Farrell, but he came and testified before the commission when I first came on, and I was very impressed with his leadership style, and I wish to extend my sympathy to Dominion employees that knew him and worked with him for over a decade as he ran Dominion Energy. He retired in April of this year and died the following day. And I know that was a tremendous loss for the company, and I'd like to express the commission's condolences to those that worked with him over that decade. And I think he set an example for us all because he really cared about his community, and he let his employees know that. So like I say, I think Mr. Farrell would have been proud of this effort on the part of Dominion executives in South Carolina, and he would have been proud of the outcome because this really is a win-win-win situation for all the parties. We've heard from all of them. They've detailed all the good things that are going to come out of this settlement agreement. Some of the things that we could never have ordered on our own. For example, there'll be no rate increase for about 2.5 years with the stay-out provision that the companies agreed to. We couldn't have ordered that as a commission. There's going to be some $30-odd million that will benefit the ratepayers that are delinquent as of May of this year because of the COVID crisis that we all encountered. And those go across the board to all classes of ratepayers. that's an impressive outcome. And finally, it's been obvious that the company made substantial concessions in their original rate increase request to the point that it's minuscule. It's really commendable that they would agree to do that, along with all these other things. But the most important thing that I like that's come from this is the reestablishment of the trust relationship that we heard about earlier, because now the parties have a track record of working together to reach a common goal. And a lot of good's going to come out of that. You've already heard the company make a commitment to continue these stakeholder processes so that everyone has input in advance. And that is a wonderful step forward. I agree with the AARP witnesses today. This is a big deal. It really is a reset of the relationship. And I commend all of you for doing the hard work over these 6 months to reach a final agreement once approved. And I haven't asked questions today because I learned when I was a trial judge that once parties settle a case, I had to give a certain amount of respect for their efforts. No settlement is perfect, but once the parties reach a universal settlement, I never thought that it would be wise to, as it was said earlier, throw out the baby with the bathwater over one issue. Then perhaps we might have decided differently. And the reason is that so much good can come from it. And I respect the chairman's concern about transmission lines, but it's been established that they are being used and they're useful to our system. Had we gone forward with the rate increase, we may have reached a different outcome. But given all the good that's come from this process, I'm of the opinion that the settlement agreement is fair, just, and reasonable. It's in the best interest of the public, the ratepayers, and it should be approved. And I'm prepared to make that motion to approve the settlement agreement so that we can get on with other business. Mr. Chairman, I so move.
Commissioner Urban has moved to adopt the settlement agreement. I'm not prepared to vote on it today. I don't know if my colleagues are prepared to vote on it today, but the motion has been made. Is there any discussion?
Mr. Chairman,
Vice Chair Belzer.
I think that the normal course is to finish taking the evidence in this case and then rule on it at an agenda meeting, which can be as early as next week, since it's not on this week's agenda.
All right.
Mr. Chair, may I make an inquiry of Commissioner Belser?
Sure.
Thank you. Vice Chair Belser, we have all the testimony and evidence in now. Is there some exhibit that has not been entered into evidence?
Mr. Chairman, none of the stipulated testimony has come in. That's part of the settlement agreement. But customarily, and I think it's a good idea, is to take the time to carefully review what we've heard and rule on it in an agenda meeting. That's just my belief, and that's my preference.
Mr. Chairman.
Commissioner Thomas.
I'd like to have some time to think about things.
All right. So the motion has been made. Is there any more discussion? Now I need to rest on my lawyer here. The motion has been made. I'm going to call a vote. but not knowing how my colleagues are going to vote, obviously, a upvote, there's no real question about what happens next. But a no vote, I don't think should be taken to mean a no with prejudice. Yes, Commissioner Caston.
You're probably answering the question I was going to ask. You know, I don't. I prefer to take the course that Vice Chair Belcher discussed, just because I wasn't really ready to do this right now. That said, if we do have to vote, I want to know, am I voting yes for, no against? Because I'm not prepared to do that.
Mr. Chairman, I would like to withdraw the motion out of respect for my commissioners, colleagues. I respect that opportunity to give us some more time, and motion's withdrawn. Thank you, sir.
All right, Commissioner Irvin's motion has been withdrawn. I think now is the time to move towards stipulating the remainder of the testimony into the record. Attorney
Chair,
Burgess.
I'm prepared to stipulate Dominion Energy's testimony into the record. If you give me 1 second to flip to my notes here. May these witnesses be seated back in the gallery?
Yes, sir.
Okay, thank you. So, Mr. Chairman, there are 4 DEC witnesses I need to just do some housekeeping issues with. I'll start with Allison Rocky, and she filed rebuttal testimony only. She had no exhibits. It was 11 pages, and I would ask that her testimony be stipulated into the record as if given orally from the stand. We also have James Neely, who filed corrected rebuttal testimony of 8 pages. He had no exhibits attached to his corrected rebuttal testimony, and I would ask that his corrected rebuttal be stipulated into the record as if given orally from the stand. Mr. Rooks had 3 pieces of testimony. Specifically, he had direct testimony consisting of 23 pages. He had rebuttal testimony consisting of 21 pages, and he had supplemental testimony consisting of 2 pages. He also had a number of exhibits, 6 in total. AWR 1 through 5 were attached to his direct testimony. I'm only going to move in from that segment from that section of exhibits. I'm only going to move in AWR 2 through 5. And the reason I'm not referencing AWR 1 just yet is that AWR 1 was corrected. So I only want to move in the corrected version of AWR 1, which was attached to his rebuttal testimony. So just to recap, that would be corrected AWR 1, and then AWR 2 through 5. And then lastly, attached to his supplemental testimony, he had AWR 6. So I'll recap that for everybody in the court reporter's benefit one more time. Corrected AWR 1, AWR 2 through 5, and then AWR 6. And I would ask that AWR corrected 1 as well as 2 through 6 will be the next hearing composite exhibit, which I believe would be 41, Mr. Chairman. And I'll pause here and let everybody kind of catch up on that before I address the last piece of testimony. If you're,
right.
if you're good, Mr. Chairman,
Yes, sir.
I'm good.
Let's go.
Okay, all right, absolutely. The last piece of testimony relates to Keith Kofer. And Mr. Kofer, there's a footnote in the settlement agreement that talked about his corrected rebuttal testimony, and that really was just a function of a date. So when Mr. Kofer stepped down from the stand and the company was going through its year-end closeout, the company realized that a date needed to be changed in his rebuttal testimony. So we filed corrected rebuttal testimony of Mr. Kofer, and the correction for his testimony is specifically found on page 6 at line 15. So we would include in the record the corrected rebuttal testimony of Mr. Kofer. So I believe I have captured all of the remaining witnesses for Dominion Energy South Carolina. I'm certainly not perfect, so if I have missed something, I know Mr. Butler's keeping score over there. He gives me the thumbs up. I think we're good to go. So that concludes the case in chief for Dominion Energy South Carolina. So thank you, Mr. Chairman.
All right, so just to recap, Mr. Neely's testimony corrected, and rebuttal testimony will be entered into the record as if given orally from the stand. Ms. Naraki's rebuttal testimony will be entered into the record as given orally from the stand. Mr. Rook's direct rebuttal and supplemental testimony will be entered into the record as if given orally from the stand, along with AWR1 corrected. AWR 2 through 6 will be marked as a composite exhibit and admitted as the next hearing exhibit. That's hearing exhibit 41. And then finally, Mr. Kofer's corrected rebuttal testimony will be entered into the record as if given orally from the stand.
That is correct. It's 2 through 6. Yes, sir.
All right. Thank you, sir. Yes, sir. Hearing exhibit 41. Let me get closer to this microphone. All right. So I think that's all from the applicant. Sierra Club.
Yes, thank you, Mr. Chairman. This is Dorothy Jaffe on behalf of the Sierra Club. On November 12, 2020, Sierra Club pre-filed in this case the direct testimony of Dr. Elizabeth Stanton, consisting of 39 pages in both a public and confidential version, along with 12 exhibits labeled as EAS-1 through EAS-12. 2 of those exhibits were marked confidential. Those are EAS-6 and EAS-8. In addition, on December 17th, 2020, Sierra Club pre-filed in this case the rebuttal testimony of Dr. Elizabeth Stanton, consisting of 11 pages. That Dr. Stanton stipulated pre-filed direct testimony and pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Dr. Stanton's pre-filed direct testimony and pre-filed rebuttal testimony will be entered into the record as if given orally from the stand, with the confidential portions remaining sealed. Additionally, exhibits EAS 1 through 12 will be marked as a composite exhibit and entered into the record as hearing exhibit 42, with the confidential exhibits remaining under seal.
Thank you.
Department of Defense and all other executive agencies.
Good afternoon, Chairman. Dr. Zen Zhu filed 65 pages of direct testimony. I would move that his direct testimony be entered into the record as it's given orally from the stand. Additionally, he filed 9 pre-filed exhibits with that testimony, and I would move that those 9 exhibits be marked as the next hearing exhibit.
Dr. Zenzu's direct and rebuttal testimony will be entered into the record as if given orally from the stand.
Okay.
Exhibits ZZ 1 through 9 will be marked as a composite exhibit and entered into the record as hearing exhibit 43.
And Chairman, I had not gone into his rebuttal yet. I know you moved his rebuttal testimony in. Along with his rebuttal, he also had 4 pre-filed exhibits to that rebuttal testimony. So we just moved those pre-filed exhibits as the next composite hearing exhibit.
ZZ rebuttal exhibits 1 through 4 will be marked as a composite exhibit and entered into the record as hearing exhibit 44.
Okay, thank you. And then Mr. Mark Garrett, he filed 80 pages of direct testimony along with 5 pre-filed exhibits to that testimony and would move his direct testimony into the record as if given orally from the stand, and then would move the 5 pre-filed exhibits to the next composite hearing exhibit.
Mark Garrett's direct testimony will be entered into the record as if given orally from the stand, and MG 1 through 5 will be marked as a composite exhibit and entered into the record as hearing exhibit 45.
Thank you. And then he also filed rebuttal testimony of 31 pages, along with 1 pre-filed exhibit. Would move that his rebuttal testimony be entered into the record as if given orally from the stand, and then would move as the next hearing exhibit his pre-filed exhibit.
All right. Mark Garrett's rebuttal testimony will be entered into the record as if given orally from the stand, and MG Exhibit 1 will be marked and entered into the record. MG rebuttal Exhibit 1 will be entered into the record as hearing Exhibit 46.
Thank you, and that concludes DoD FEA's testimony in this case.
Thank you, ma'am. Department of Consumer Affairs.
Thank you, Mr. Chairman. We had 3 witnesses in the matter. Our first discussed was Dr. Dismukes, had 69 pages of direct testimony, which also included 23 pages of exhibits. There was a confidential and public version of those documents. The exhibits are DED 1 through DED 14.
Dr. Dismukes' direct testimony will be entered into the record as if given orally from the stand, with the confidential portions remaining under seal. DED 1 through DED 14 will be marked as a composite exhibit and entered into the record as hearing exhibit 47.
Thank you. Dr. Dismukes also filed 18 pages of rebuttal testimony, including, or with, in addition, exhibits DED 1 and DED 2.
Dr. Dismukes' rebuttal testimony will be entered into the record as if given orally from the stand, and rebuttal exhibits DED 1 through 2 will be marked as a composite exhibit and entered into the record as hearing exhibit 48.
Mr. Chairman, could I ask a question, please?
Yes, ma'am. Vice Chair Belzer.
With regard to hearing exhibit, what's now marked as 47, there were 14 exhibits, but wasn't there also an appendix? Is that supposed to be part of the hearing exhibit?
Attorney Metlin?
No, Mr. Hall.
I'm sorry.
I don't have it in front
Mr.
of me, but
Hall.
I believe, yes, if the appendix was filed, then yes, it should also be included.
Could the record reflect that on Dr. Dismukes' appendix also be included in hearing exhibit 47?
Dr. Dismukes' appendix to his hearing exhibits will also be included in exhibit 47. Thank you, Vice Chair Belzer.
Thank you. Our next witness was Mr. Aaron Rothschild, who had 90 pages of direct testimony and 20 pages of exhibits marked ALR 1 through ALR 6.
Dr. Rothschild's direct testimony will be entered into the record as if given orally from the stand, and AR 1 through 6 will be marked as a composite exhibit and entered into the record as hearing exhibit 49.
Mr. Rothschild also filed 20 pages of rebuttal testimony and had one exhibit with that testimony, ALR 1S.
Dr. Rothschild's rebuttal testimony will be entered into the record as if given orally from the stand, and his rebuttal exhibit will be marked as ALR 1S and entered into the record as hearing exhibit 50.
Thank you. Finally, we had Mr. Scott Hempling, who filed 57 pages of direct testimony.
Mr. Hempling's direct testimony will be entered into the record as if given orally from the stand.
Mr. Hempling also filed 11 pages of surrebuttal testimony.
Mr. Hempling's surrebuttal testimony will be entered into the record as if given orally from the stand.
And finally, he filed 13 pages of responsive testimony.
Mr. Hempling's responsive testimony will be entered into the record as if given orally from the stand.
Thank you. And just as a matter of update, we have 2 outstanding verifications left to submit for 2 of our witnesses that should be coming shortly at request of Mr. Butler.
Okay,
Thank
thank you.
Before Mr. Hall leaves, we had that Mr. Hempling had.
Attorney Butler, if you could get to a microphone, please, sir.
Okay,
You may need to go to the podium.
all right. Over there. Okay. Okay, thank you, Mr. Chairman. According to our records, there were 2 appendices for Mr. Hempling, one connected with his direct and one connected with his responsive. Those are normally brought in as exhibits if the parties.
I counted, sorry, with the responsive testimony, I just included in the 13 pages, I believe it was 11 pages of testimony, and yes, 2 were the appendix. If you prefer to make them as the hearing exhibit.
Yes, sir, if you don't mind,
Sure.
I think that would be better for our record.
Okay. So, Mr. Chairman, then for Mr. Hempling's responsive testimony, it would be 11 pages of responsive testimony and 2 pages of an appendix. That would be a hearing exhibit.
Mr. Hempling's appendix, you said 2, what, I'm sorry, say it again?
He just labeled it as an appendix.
An appendix.
So, but it consists of 2 pages.
Okay. The document labeled an appendix existing of 2 pages that was submitted with Mr. Hempling's responsive testimony will be marked and entered into the record as hearing exhibit 51.
Okay, good, thank you.
Okay, thank you.
Okay, Mr. Hall, I'm sorry, one more time. We have a record, there's an appendix for direct and one for responsive, apparently, in a list. Would that include the 2 pages that you just did?
And I apologize, I don't have it in front of me. Was the appendix for his direct, just was it that his resume?
Yes, sir. Uh-huh.
I will leave it up to the commission to decide how to enter. I would be fine with that just being part of his testimony. If you prefer to have it be an exhibit, that's acceptable.
Yeah, we normally like those as exhibits also.
Okay, and lean on you to
Sorry.
tell me how many pages that was, or just the
No,
appendix?
I can't tell, just the appendix.
Okay.
You can just cite it as the appendix.
Sure. Well, then, Mr. Chairman, we move to have the appendix from Mr. Hempling's direct testimony entered as a hearing exhibit.
The appendix from Mr. Hempling's direct testimony will be marked and entered as hearing exhibit, I believe 52, or room 52 or 51. 52.
It'd be 52, and I assume 51 would be the responsive appendix.
All right. Okay.
Thank
Is
you.
Mr. Hall good to go now?
Or from the staff's perspective, yes.
All right. Thank you, Mr. Hall.
Thank you.
Thank you.
Frank Knapp Jr. Mr. Knapp was excused earlier this morning. Walmart.
Good afternoon. Ms. Perry filed direct testimony on November 10, 2020, consisting of 17 pages, and we would move to have that admitted as if read orally from the stand.
Ms. Perry's direct testimony will be entered into the record as if given orally from the stand.
And attached to Ms. Perry's direct testimony were 3 exhibits, LVP 1 through 3, totaling 11 pages, and we would move to have those 3 exhibits admitted as the next composite hearing, Exhibit 53.
LVP 1 through 3 will be marked as a composite exhibit and entered into the record as hearing exhibit 53.
Ms. Perry also submitted surrebuttal testimony filed December 17, 2020, consisting of 7 pages, and we would move to have that entered into the record as if given orally from the stand.
Ms. Perry's surrebuttal testimony will be marked and entered into the record as if given orally from the stand.
And finally, her verification was submitted to the commission on July 7th, 2021, with respect to both her direct and her rebuttal testimony. And this concludes Walmart's testimony in this docket.
Thank you, ma'am. AARP.
Yes, Your Honor. This is John Kaufman for AARP. We have one expert witness who has 2 pieces of testimony to be stipulated. Scott Rubin has, I think, 51 pages of direct testimony, and Scott Rubin has surrebuttal testimony of, I think that's 12 pages of testimony. And we would respectfully ask that those be entered into the record.
Thank you, sir. Mr. Rubin's direct and surrebuttal testimony will be entered into the record as if given orally from the stand.
And Your Honor, the verification on that has been distributed to the parties and to Mr. Butler, but we still need to file that later this afternoon.
All right. Thank you, sir. South Carolina Energy Users Committee.
Mr. Chairman.
Attorney Butler.
Yes, sir, Mr. Chairman. We had a record, Mr. Rubin's had direct exhibits 1 through 3 in Appendix A, and then a surrebuttal exhibit, it appears, as well. Mr. Kaufman, could you help us with that?
Yes, if you would like to have those separated out into a separate appendix or exhibit, that would be fine.
Yes, sir. Yes, sir. We have Appendix A with a direct, and then exhibits SJR 1 through 3 for his direct. That would be his first exhibit, which would be, I guess, 54.
Okay.
All right.
That sounds right.
SJR 1 through 3 will be marked as a composite exhibit and entered into the record as hearing Exhibit 54.
Yes, sir. Mr. Chairman, I assume that would include his Appendix A also.
SJR 1 through 3 also includes Appendix A.
Yes, sir. Then he also has surrebuttal exhibits, SJR 4 and 5.
Yes, that's right.
SJR 4 through 5 will be marked as a composite exhibit and entered into the record as hearing Exhibit 55.
Thank you, sir. Thank you, Mr.
Got
Kaufman.
it. Thank you.
Thank you, Mr. Kaufman.
Attorney Elliott.
Thank you, Mr. Chairman. We would stipulate into the record at this time the testimony of Kevin O'Donnell and Edward G. McGavran. First, Mr. O'Donnell filed 30 pages of direct testimony with one appendix. We would move that into the record or stipulate that into the record.
Mr. O'Donnell's direct testimony will be entered into the record as if given orally from the stand. And are you also moving the appendix in as an exhibit?
Please, sir.
And Mr. O'Donnell's direct appendix will be marked and entered into the record as hearing Exhibit 56.
Thank you, sir. And Mr. O'Donnell pre-filed 25 pages of surrebuttal testimony, and we'd stipulate that into the record at this time.
Mr. O'Donnell's pre-filed surrebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, sir. Mr. McGavran pre-filed 16 pages of direct testimony with one appendix and 3 exhibits. I would first stipulate the direct testimony of Mr. McGavran into the record.
Mr. McGavran's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, sir. And now I would move his appendix and 3 exhibits into the record as hearing Exhibit 57.
Mr. McGavran's appendix and 3 exhibits will be marked as a composite exhibit and entered into the record as hearing Exhibit 57.
Thank you, sir. And last, I would stipulate into the record Mr. McGavran's surrebuttal testimony consisting of 13 pages.
Mr. McGavran's surrebuttal testimony will be entered into the record as if given orally from the stand.
Thank you very much, sir.
All right. South Carolina Coastal Conservation League, Southern Alliance for Clean Energy. I see there are no witnesses. Is that correct?
Yes, Mr. Chairman.
All right. All right. Office of Regulatory Staff.
Thank you, Mr. Chairman.
Yes, sir, Attorney Bateman.
We have, as you're aware, a number of direct, surrebuttal, some revised, a number of exhibits. I'm happy to go through each one individually. I'm also happy to submit a single composite exhibit consisting of all of the exhibits, if you would be comfortable with that, while stipulating the direct, surrebuttal, and revised testimonies into the record as if given orally from the stand. I'm flexible and clearly defer to the commission. I just wanted to present those two options because one is rather tedious and the other is less so.
Thank you for your flexibility. I'll look to our attorney on this case. What's your preference, Attorney Butler? I'm fine with either.
Okay, thank you, Mr. Chairman. Hate to say it, but I'd like to elect a tedious option.
Absolutely.
That's the only way to keep the record really straight.
All right. Well, let's start from the
Thank you.
top and take them one by one.
Yes, sir, Mr. Chairman. Thank you, Mr. Butler. And I don't believe I'll miss anything, but in the event I do, please let me know. And I also understand that we filed the verifications about an hour and a half ago of all of our witnesses, so they should be on DMS at this point in time.
Thank you.
Okay. I'll start with Mr. Thompson, Ryder Thompson. He filed revised direct testimony with the Public Service Commission on December 23rd, 2020. It consisted of 10 pages. I'd ask that it be read into the record as if given orally from the stand.
Ryder Thompson's revised direct testimony will be read into the record as if given orally from the stand.
Thank you, Mr. Chairman. Next, Mr. Chairman, I have Anthony Sandinato. Mr. Sandinato pre-filed direct testimony with the Public Service Commission on November 10th, 2020. It consists of 7 pages. I'd ask that Mr. Sandinato's pre-filed direct testimony be read into the record as if given orally on the stand.
Mr. Anthony M. Sandinato's direct testimony, pre-filed direct testimony, will be read into the record as if given orally from the stand.
Thank you, Mr. Chairman. Next, I have Mr. Dr. Woolridge. I have his revised direct testimony with appendices and exhibits. His revised direct testimony, appendices, and exhibits were pre-filed with this commission on January 21st, 2021. Consists of 95 pages, appendices A through C, and exhibits JRW1 through JRW10. I respectfully request that Mr. Dr. Woolridge's testimony, his pre-filed revised direct testimony, be read into the record as if given orally from the stand.
Dr. J. Randall Woolridge's pre-filed direct testimony will be entered into the record as if given orally from the stand, along with appendices A through C and JRW1 through JRW10 will be marked as a composite exhibit and entered into the record as hearing exhibit 58.
Thank you, Mr. Chairman. And to be clear, on the exhibit list sent out Friday evening just after 6 by the Madam Court Reporter, I think that may have included his original pre-filed appendices in the exhibits. So we would respectfully request that the revised be submitted into the record.
The revised appendices will be entered as, in addition to JRW 1 through JRW 10, will be entered into the record as hearing exhibit 58.
Thank you, Mr. Chairman. Next, we have Daniel Sullivan. Mr. Sullivan pre-filed 18 pages of direct testimony on November 10th, 2020, and 8 exhibits. I'd respectfully request that his direct testimony be read into the record as if given orally from the stand, and that his 8 exhibits be marked as the next composite hearing exhibit.
Mr. Daniel F. Sullivan's pre-filed direct testimony will be entered into the record as if given orally from the stand. Mr. Daniel F. Sullivan's 8 exhibits will be marked as a composite exhibit and entered into the record as hearing exhibit 59.
Thank you, Mr. Chairman. And Mr. Sullivan also pre-filed 3 pages of surrebuttal testimony and 9 exhibits with this commission on December 17th, 2020.
Mr. Daniel F. Sullivan's pre-filed surrebuttal testimony will be entered into the record as if given orally from the stand. Mr. Daniel F. Sullivan's surrebuttal exhibits 1 through 9 will be marked as a composite exhibit and entered into the record as hearing exhibit 60.
Thank you, Mr. Chairman. And I realized, and I may have said this, so I apologize if I'm repeating myself, but I wanted to confirm the surrebuttal testimony of Dr. Woolridge, consisting of 27 pages, submitted on December 17th, 2020. I wanted to confirm that that was entered into the record as if given orally from the stand.
I think that it was,
Okay.
but just in case it wasn't, Dr. J. Randall Woolridge's surrebuttal testimony will be read into the record as if given orally from the stand.
Thank you, Mr. Chairman. Let's see. Next, I have the ORS witness, William C. Cleckley. I'd respectfully request that Mr. Cleckley's direct testimony, which is filed on November 10th, 2020, and consisted of 15 pages, be read into the record as if given orally from the stand.
Mr. William C. Cleckley's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you. And next, I would respectfully request that Mr. Cleckley's surrebuttal testimony, which was pre-filed with this commission on December 17th, 2020, and consisted of 5 pages, be read into the record as if given orally from the stand.
Mr. William C. Cleckley's pre-filed surrebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Next, I have ORS witness Anthony D. Brazino. I would respectfully request that witness Brazino's direct testimony, which was filed with this commission on November 10th, 2020, and consisted of 18 pages, be read into the record as if given orally from the stand.
Mr. Anthony D. Brazino's pre-filed direct testimony will be entered into the record as if given orally from the stand.
And Mr. Brazino also filed on December 17th, 2020, 3 pages of surrebuttal testimony. I would respectfully request that that be read into the record as if given orally from the stand.
Mr. Anthony D. Brazino's pre-filed surrebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Next, I have ORS witness David J. Garrett. Mr. Garrett pre-filed direct testimony on November 10th, 2020, consisting of 41 pages, appendices A through C, and exhibits DJG1 through DJG19. I respectfully request that Mr. Garrett's pre-filed direct testimony of 41 pages be read into the record as if given orally from the stand.
Mr. Garrett's pre-filed direct testimony will be entered into the record as if given orally from the stand. Mr. David J. Garrett's appendices A through C, along with DJG 1 through 19, will be marked as a composite exhibit and entered into the record as hearing exhibit 62.
Thank you, Mr. Chairman. And next, I'd respectfully request that Mr. Garrett's surrebuttal testimony, which was pre-filed on December 17th, 2020, and consisted of 8 pages, be read into the record as if given orally from the stand.
Mr. David J. Garrett's pre-filed surrebuttal testimony will be read into the record as if given orally from the stand.
Thank you, Mr. Chairman. Next, I have ORS witness Lane Collin. I would respectfully request that Lane Collins' he pre-filed both public and confidential direct testimonies on November 10th, 2020, consisting of 29 pages, as well as exhibits LK1 through LK9. I'd respectfully request that his public direct testimony be read into the record as if given orally from the stand, and his confidential testimony be put into the record with and maintained under seal.
Mr. Lane Collins' direct testimony will be entered into the record as if given orally from the stand, with the confidential portions remaining under seal. LK1 through LK9 will be marked as a composite exhibit and entered into the record as hearing exhibit 62.
Thank you, Mr. Chairman. Next, I would respectfully request that Mr. Collins' surrebuttal testimony, which was pre-filed with this commission on December 17th, 2020, and consisted of 19 pages, be read into the record as if given orally from the stand.
Mr. Lane Collins' pre-filed surrebuttal testimony will be entered into the record as if given orally from the stand.
And I would respectfully request that Mr. Collins' surrebuttal exhibit LK1 be marked for identification as the next hearing exhibit.
Mr. Collins' surrebuttal exhibit LK1 will be marked and entered into the record as hearing exhibit 63.
Thank you, Mr. Chairman. Next, we have ORS witness Brandon Bickley. I would respectfully request that Mr. Bickley's direct testimony, which is pre-filed with this commission on November 10th, 2020, and consists of 29 pages, be read into the record as if given orally from the stand.
Mr. Brandon S. Bickley's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. And next, I would respectfully request that Mr. Bickley's rebuttal testimony, which is pre-filed with this commission on December 17th, 2020, and consists of 10 pages, be read into the record as if given orally from the stand.
Mr. Brandon S. Bickley's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. And finally, let me find my paper. I would respectfully request that the revised direct testimony of ORS witness Seaman Nguyen, which was pre-filed with this commission on January 21st, 2021, and consists of 23 pages and 6 exhibits with a revised exhibit MSH 6, that the testimony be read into the record as if given orally from the stand, and that the exhibits, including the revised exhibit MSH 6, be entered into the record as the next composite hearing exhibit.
Mr. Michael L. Seaman Nguyen's revised direct testimony will be entered into the record as if given orally from the stand. Revised MSH 6 will be marked as a composite exhibit and entered into the record as hearing exhibit 64.
Thank you, Mr. Chairman. And to be clear, exhibits 1 through 5 are included in that composite hearing exhibit. Is that correct?
That is correct. Exhibit 64 should include MSH exhibits 1 through 6 as a composite exhibit.
Thank you, Mr. Chairman. Next, I would respectfully request that Mr. Seaman Nguyen's revised rebuttal testimony, which was also filed with this commission on January 21st, 2021. It consists of 10 pages as well as 3 exhibits, a revised rebuttal exhibit MSH 3, that the testimony be read into the record as if given orally from the stand, and that Mr. Seaman Nguyen's exhibits 1 through 3, including that revision, be marked for identification and entered into the record as the next composite hearing exhibit.
Mr. Michael L. Seaman Nguyen's revised rebuttal testimony will be entered into the record as if given orally from the stand, and Mr. Michael L. Seaman Nguyen's revised rebuttal exhibits MHS 1 through 3 will be marked as a composite exhibit and entered into the record as hearing exhibit 65.
Thank you, Mr. Chairman. And finally, I would respectfully request that the responsive supplemental testimony of ORS witness Seaman Nguyen, which was filed with this commission on December 23rd, 2020, and consists of 3 pages, be read into the record as if given orally from the stand.
Mr. Michael L. Seaman Nguyen's pre-filed supplemental testimony will be entered into the record as if given orally from the stand. Now, was that a revision as well, or no revision on the supplemental?
No, Mr. Chairman. The responsive supplemental testimony, there's no revision to that. It was filed on December 23rd, and that is the testimony as it stands.
All right. Okay.
And Mr. Chairman, I believe that is all. I believe I got all the testimonies and all of the exhibits. So, like Mr. Burgess, I am certainly not perfect, and to the extent I missed anything, please let me know. The verifications have been filed with the commission, and I certainly appreciate your time.
All right. Thank you.
Mr. Chairman, I apologize. One final thing. I wanted to confirm Ms. Hipp is excused to leave. I wanted to confirm that, Mr. Chairman.
Yes.
Okay. Thank you, Mr. Chairman.
Mm-hmm. All right. Let's talk about proposed order deadlines. Applicant, ORS, proposed order deadlines.
Mr. Chairman. Mr. Chairman, I believe that Mr. Butler had proposed August 2nd. Yes, sir. I understand that the commission has a deadline of August 16th to issue its final order, and provided the other parties are amenable to August 2nd, ORS is certainly willing to work with Dominion and the other intervenors to work towards a date of the proposed order of August 2nd.
Any objection to August 2nd proposed order deadline? Hearing none, the proposed orders are due August 2nd. Madam Court Reporter, the parties should expect the final transcript July 27th. Okay, and that July 27th, the court reporter confirmed that the transcript will be complete and in the hands of the parties requesting the transcript. Is there anything else that we need to discuss before we adjourn this hearing?
Mr. Chairman.
Attorney Butler.
Yes, sir. One more thing. Speaking of tedious, I don't think you want me to stand here and read through all these exhibits again. I'll be more than glad to furnish a list to all parties of all the hearing exhibits, so you'll have the numbers for your reference if you need them, if that's acceptable to the parties.
All right, everyone is shaking their head in agreement, yes.
Thank you.
And we are adjourned.